May it please your lordship. Would you consent on the other side? I beg to mention item number 86 of the daily dismissal.
86.
An affidavit in opposition filed by the SSA department has been sent for vetting to them, my lord. My lord, may I please to take up this matter in the next week, my lord.
Who's appearing for the applicants? Have you informed?
My lord. Other side.
Have you informed the other
Yes, my
side?
lord.
Okay. When do you want?
After 26, my lord.
Okay, on request made by Mr.
H. Burua.
H. Barwal, Learned
Appearing on behalf of Mr. B. Gogoi, my lord.
Learned Council appearing on behalf of B. Gogol, Learned Standing Council Health Finance.
SSA, my lord.
Learned Standing Council SSA. List on 3rd October. Yeah.
Highly obliged.
May I beg to lordship? Lordship, I beg to mention listing of contempt matter.
Okay. First of October.
May I please your lordship, I'd like to mention for listing WPC 3809/2024. Notice has been issued and the date has expired, so it may be listed on Friday.
Third.
And one more is there. WPC 3787.
Same day. Same date.
Oh, obliged.
May I plead your lordship? I beg to listing a matter. This is appointment relating matter. Last order given 4 weeks, but that is already over.
First of October.
May I please, lordship? I beg to mention for listing, my lord, the two admission matter. On 20th or 21st? 20th.
We'll have it on 27th.
My lordship, item number 21. Kindly may take the matter at 2 p.m. Kindly,
Why 2 p.m.?
because senior is on the way, he's in hospital right now, so kindly may take.
You wait. I'm not fixing time. Yeah. Next.
May please, Lord. I'm praying for listing, Lordship, contempt matter, Lordship. It will come in order, Lordship, on the next week, Lordship, any day. On Monday, Lordship.
30.
Fine. I'm paying for listing or withdrawal, lordship, day after tomorrow.
89 of supplementary list withdrawal.
Pursuant to your lordship's interim order, my lord, I was upgraded to a better stream, my lord. So, my lord, the cases become infractions as of now. It is relating to the admission in the engineering college, my lord.
Petitioner get relief, lordship. She was enrolled in the electronics department.
Okay, Mr. Ardale and the counsel for the petitioner submits that the matter has become in practice. Mr. K. Google and the standing counsel appears on behalf of the higher education department. With petitioners accordingly, this is now the same practice.
22 of daily list. Admission, personal affairs.
Yes. Headmaster is present. You're the headmaster. Why are you not filing your affidavit despite notice being served?
Can I assist, lordship?
You can't understand English? You don't understand English.
English cover now. Unable to.
You are the headmaster of a school.
Photo medium.
Photo
medium. Yes.
Someone please assess.
Yes, Lord, I am this lordship.
Yeah.
He is the headmaster, in charge headmaster, lordship. He has appointed on March this year, lordship. But he did not receive any notice from this court, lordship. First received registered notice, so it issued on 28/8/2024, lordship. On 6/9/2024, he received notice.
Lordship, I'm just interrupting because we have personally served copy on him and he has signed that we have filed an affidavit stating that. How can they say we have not received notice?
Where's your affidavit?
Affidavit was filed on Lordship serial number pages 48. What different pages?
Page-
47 onwards. It was filed on 12th of February 2024.
No, no,
Month of February itself we filed it.
you filed an affidavit, isn't it?
Yes,
It's an affidavit.
serial number pages 47 onwards.
No, your paging is wrong. That was served on 25/1/2024.
Order.
It was served on 25/1/2024, correct?
Yes, Lordship, yes, yes.
He took over charge in March only. When did he take charge?
20 March, lordship.
Huh?
20 March 2024.
20 of March.
20 March.
You are representing him?
Yes.
You are representing him?
Yes, lordship. Today I am representing him. Further, I will file you affidavit. You call them, lordship.
You are filing Wakalatnama.
Yes, sir. Today I am filing.
Okay. When are you filing your affidavit?
Vacation, lordship.
I'll give you 1 week time.
At least 2 weeks, there may be. Lordship, in the meantime, lordship, a petition may be, that may be given to submit petition, lordship, copy.
You have an extra copy?
Will serve.
If you have now, you can serve it on your.
Right now, I don't have, but I'll serve it on the advocate during the course of the day, after some time will serve.
Okay. Her time is the Borgohan Learned Council for the petition. Stop. Para. The respond number 9, oblique headmaster of Kamal Singh MB School, Kokracha, is present in court today and submits that he has taken over charge as in charge headmaster
In charge.
on 20 March 2024. He therefore on and is not aware about dependency of this regulation. It is however submitted that he has engaged Mr. J.U. Ahmed, Learned Council, and prays for 2 weeks' time to file affidavit. The prayer is allowed without fail.
Yes, lordship.
Release the matter. It has to come after puja already. On 23rd of October 2021. Stop. The personal appearance of the respond number 9 is dispensed with for the time.
Problem.
One of the Lily motion.
Finally, in this case, I need some time, lordship. They did come on Friday next, lordship. That's, I was directed to take the instruction regarding, lordship, the process as per Annexure 5, lordship, regarding the, what the process regarding full-fledged president. But that instruction hasn't come, though I have received some instruction earlier, lordship, that as per clause 1, lordship, serial number 2, 11 serial number 2, now he was terminated and neither lordships and the DO was given the charge of president. Now DO is holding the charge. So as such lordships,
Okay, heard.
Your lordship on 31/7/2024, 2 weeks time was granted for obtaining instruction. But impugn order was passed much earlier. On
My lord, he was arrested.
9/1/2024.
that instruction I have received lordships. Or earlier occasion on 7/12/24 I have received the instruction.
But
That instruction I have already noticed.
for further instruction, he has taken time, my lord.
Further instruction regarding lordship,
31/7/2024. If the instruction is not coming, my lord, then in that case, on material on record case may be decided.
DO is holding the charge, but there's nothing to be decided. The criminal
No,
case, he has
no,
not
why
acquitted
I have been
lordship.
removed? That is my allegation, my
Criminal
lord.
case is pending,
My
he is
lord,
not yet been
either
acquitted.
my learned friend will
Okay,
submit
okay, heard
that he
Mr.
will
M.A. Sheikh, Learned Council for the.
obtain instruction or argue the case.
First made by Mr. S.M.T. Chichdi, then Standing Council Secretary Education Department. When do you want, this Friday?
Next week, lordship.
Next
My lord,
week.
only to delay the matter, my
No, no, don't worry about it. The court will take care of.
my lord.
My lord, otherwise that
We'll have it
memorandum.
on 25th.
Yes.
List the matter on 25th to enable him to receive it.
Otherwise, there is a clear
My lord,
provision in
that-
memorandum, lordship.
That may be the
nobody
last chance
can
of the
terminate
obstruction.
anyone.
Okay, okay.
My lord,
You get your instructions,
Yes.
then we'll dispose this matter.
Yes,
my
lord.
lord, it may be last chance, my lord. Otherwise, time will be taken, time and again.
Uh-huh.
My lord, that person functioning DO is in charge, lordship,
Okay, okay.
and the school is not.
Let it
functioning.
come up.
Yes. So,
No, my lord, he is submitting that DOI is functioning, but I have been removed illegally.
That's
That is
correct.
my case. So, my lord, that may be the last chance, my lord. Otherwise, my
We'll
lord,
see.
again, they will take time.
Yes.
so
In this case, on last occasion, I was directed to bring inspection.
Oh.
I have received the parawise, madam. Let us file our affidavit, madam.
You want to file your affidavit?
My lord, I have received the parawise, madam.
What does your parole say?
Well, here, my lord, petitioner was absent on that day when general meeting was held. And he has stated only 23 numbers of parents were present there, but as per the proceeding book, there are 56 numbers of parents were present there.
Okay. Heard, Mr.
And Jaman.
N. Zaman, Learned Counsel for the petition. Mr. B. K. Bora, Learned Standing Counsel, Elementary Education Department, submits that he has received instructions. And prays for how much time?
15 days, ma'am.
Prays for 2 weeks time to file applications. Praise the Lord. Please, after the puja vacation.
Obliged, ma'am.
Obliged.
May I please, yes. This is a petition for appointment under compensated ground. And DLC meeting is going to be held on the 19th of this month. And she has been instructed to submit the certified copy of the case on by 18th or before 18th of this month. If the case is pending, then they will not consider her application. And also in earlier occasion, your lordship, this petitioner has approached this honorable court on the page at 47, where the honorable court was pleased to pass an order to consider her application based on the merit in the year 2019. Until date, her application was not considered.
Yes, state psychiatrist. Have you placed the case of the petitioner before the DLC?
My lord,
Huh?
my lord, various occasion, this has placed, my lord. It has placed on 22/2016, 26/9/2016, 15/5/2017, 13/11/2017, 12/4/18, 25/7/2018, and 9/8/2021, and 14/2/2022. Many occasion, my lord, it has placed, my lord.
And then what is the outcome of that?
Then, my lord, till, my lord, 2018, it has rejected, my lord, due to under vacancy.
Then
And after the honorable court order, my lord, again it has placed, my lord, but this is rejected, my lord.
when was it
By saying that
rejected?
is, my lord.
On the last occasion, when it was rejected, it was based on ground of delay, your lordship.
1 minute.
Your lordship may check the page number 47 is the order passed by this honorable court, where direction was being issued that not for the ground of delay, her application should not be rejected. It may be put on the merit. And since then, she has not been informed till date whether her application is considered. She has made RTI applications also. But this time she has been instructed by the office that on 19th, the VLC meeting will be held. So before 18th, she has to submit the certified copy, and if the case is pending, her application will not be considered.
Is that correct, Saikya?
My lord, that is number 44, my lord. They said rejected on time lapse, my lord. By following.
No, when was the last DLC meeting?
Last PLC meeting, my lord. 14/2/2022, my lord.
14?
14/2/2022.
On the day, what happened?
On that day, my lord, this is rejected, my lord.
On what grounds?
Grounds on the time lapse, my lord. Because, my lord, the case of the petitioner, my lord, many occasions placed before the DLC, my lord, but due to one-time vacancy, that was not.
Have you furnished a copy to him?
Lordship, how can it be on the
Copy-
timeless? Because 2000.
1 minute.
Copy, my lord, he has already enclosed, my lord.
Copy he has enclosed. You have enclosed in the writ petition.
Which copy?
It is
A certified copy of
last
the
rejection.
last rejection. Last rejection was before 2019. Before
No. He's saying 2022.
No. We are not informed. We have no knowledge of the same.
Sir, 2016, my lord, 9/8,
Let me have
2019,
a look at the DLC minutes.
my lord. My lord, may please to take up after some time, my lord, because my lord, some DLC was there, my lord.
Okay, get the minutes.
My-
Take
my-
up after some.
My lord.
Or
Lordship, may kindly tell the last order, Lordship. Lordship was pleased to direct the PTC authorities to place instruction regarding the page 43, Lord.
My lord. As my senior is out of station, he instructed me to state that Director of Education of BTC has sought 1 week time to give instructions.
I don't understand.
My lord,
Are you the standing counsel?
I'm on behalf of SR. He instructed me to say that Director of Education of BTC has sought.
Can this court take that instruction when you're not the standing counsel?
Actually,
How many standing councils are there BTC?
approximately 6.
5 more 6,
6.
Where are the other councils?
more than 7.
They are not here. My lord.
This is absolutely, Lordship, what is going
Are
on.
you his junior?
Yes, my lord.
He could have instructed the other BTC council to appear, not you. You're not the standing council BTC.
Yes,
When is he coming back?
well, probably tomorrow.
Then we list it day after tomorrow.
Yes.
But our Learner Council for this. On request made on behalf of Mr. S. R. Ramba. Learned Standing Council BTC. This is on- We'll have it on Friday.
Lordship.
Let him get.
Okay.
May I please, Your Lordship?
Yeah.
Lordship, this matter last occasion, Standing Council Guwahati University asked to obtain instruction.
We have received the verbal instruction. Lordship, my senior is on the way. We will to some time. May I pray an adjournment for the time?
Okay.
Thanks.
May I please, Your Lordship? Lordship, similarly situated petition have been disposed of by this honorable court by dated 14/8/2024. My lord, page number 49, annex 11. My
Page number,
page number 49, annex 11.
counsel. Your writ petition is not paginated. How the filing section is accepting this type of? There's no pagination.
My lord, I will do the correction. My lord.
The present writ petition is not paginated. The counsel for the petitioner shall paginate the writ petition within a period of, within the course of the day, list after 1 week.
Lordship, in this case, I am praying for a notice. The Lordship has already entertained a similar repetition.
Yes, notice should go as if
Notice.
Let's
And Lordship
take
is an
that.
observation that pendency shall not be abandoned. Same repeat.
Very heavy reason, only it's low. Wait, wait.
This is with regard to,
Lordship, I am seeking similar benefit with regard to common judgment dated 6/3/2017 at page 98. It starts with page 98 and it ends with page 108.
okay, heard Mr.
SK Das.
SK Das, learned counsel for the petitioner. Issue notice.
I have for 2 and 3, Lordship.
One, Mr. P. Cycle and a government advocate appeals for respond number 1. Mr. SMT Chishti, learned standing counsel, secondary education appeals for respond.
2 and 3.
2 and 3 finance.
Eh.
Mr. MS,
RM.
RM Barwa, learned counsel, standing counsel finance. Appeals for the respond. Notice on respondents are complete.
Picture of the 4.
However, extra copies. Respondents are allowed to file their affidavits. List of the 4 weeks. Pendency of this writ petition shall not be a bar on the part of the respondent to consider the case of the petition.
Problem.
Huh? Eight, element 8.
This matter relating to overstay and recovery lordship, for which lordship the pension and pensioner benefit has not been released. Well, if you lordship kindly come to page 47.
Page
47, that is the service book lordship. As per service book lordship, my date of birth was recorded 13/1/1965. And as per this date of birth lordship, my date of retirement would be 31/1/2025.
okay.
Now lordship may kindly come to page 52. This is the in letter lordship. Page 52. This is the letter dated lordship 6/8/2024. With reference to the above, you are hereby informed that as per admit card and examination birth certificate, your date of birth is 1/9/1960. As per your date of birth, your date of retirement is 30/9/2020. Therefore, you are hereby requested to take retirement on 30/9/2020. And you are also requested to hand over the charges and government documents to the senior most officer of the school. Now, lordship, page 54, another letter, lordship. As per this letter, page 52, my date of retirement is 30/9/2020. But lordship, this notice was issued on 6/8/2024. But this notice was issued on 6/8/2024, saying that
Which notice?
lordship, page 52.
52.
52. They are saying that date of retirement as per lordship admit card 30/9/2020.
but notice was issued after lordship almost more than 3 years.
So you asked to retire.
Lordship pays 54. I have been directed to refund the excess amount, and otherwise your pension document will not be processed. Last line. It is a matter on record, lordship, the petitioner has served during that period, lordship. And at my humble submission, lordship, at this instance, notice may issue and provisional pension may be directed to be released, and so far this recovery is concerned, that may be state lordship.
Yeah, Fukan, are you happy?
But this is not issued, woman.
Notice is going. What about the recovery?
My lord, he was, retired as a headmaster, my lord, and he is.
You allowed him to work. And then backdated, you sent him on. I think a similar matter I've disposed.
Yes, lordship. In that case, I was at.
Oh, that's same matter. But M. Khan and a council for the petition.
But this is not issued, woman.
Issue notice. MS N. Fukan, Leonard, standing council. Elementary
My lord,
Anyway,
appears for the respondent. 1,
1, 5, 6, and 7, my lord.
1, 5, 6, and 7. Pension, Mr. P. Cycle and Governor appears for the respondents. 2 and 4. And finance, MS RM Barwal and standing council finance appears for the respondent. Notice and respondents are complete. However, except copies of the issue to service. Respondents are allowed to file affidavit. List of the 4 weeks. I'll have to stay this order 8/8/2020
My lord,
in the interim.
My lord, I will be allowed to take instruction.
No, this is for refund of salary that you stay for something. The communication dated 8/8/2024. Issued by the Deputy Inspector of School, Sutia, Chapakua, and addressed to the petitioner. Whereby
My lord, as a headmaster, he has retired, my lord. And as a headmaster, he was the only drawing and disbursing power he has, my lord.
so
So he know,
okay,
he
that
knew.
will take part, will take.
He knew everything, my lord.
The
What's going on, my lord.
whereby the petitioner was directed to return the monthly salary received from 1/10/2020 to 36/2024. Shall remain suspended till the next returnable date. How about a provisional pension? The prayer for provisional, the prayer for the issuance of provisional pension to the petitioner shall be considered on the next returnable date. We'll consider on the next.
9.
May it please the Lord.
Yeah.
One of the 3 petitioner herein were appointed as assistant teacher of the lower primary school in the year 1995-1996. Thereafter, my lord, they were regularized in the year 2005. As regards imposition of the new pension rules, 2009, there was a debate between the government and the petitioners. Ultimately, the debate rested before the division bench, and the division bench judgment is at page 125. Second paragraph onwards.
Yes.
That the writ appeals were respectively agreed such and such. Issuance of direction state government to grant them pension as per such and such old pension. These appeals relate to such and such OBE teachers. Ultimately, the observation is in the second paragraph. That the appellants were appointed in, I am appointed in 95-96. Here the appellants were appointed, second paragraph in 126. The learned counsel of the appellant submit the appellants were appointed in the year 2001. Therefore, the cases come in the ambit of apostate decision of the meeting. It is further submit the issuance of regarding extended benefit of old pension scheme to those employees who joined the government service after 2005, wherein the recruitment process started prior to 2005 in pending the administrative department. In view of the above development, we are of the view that once the state government had decided to consider the demand of the employees who were though appointed after 2005, wherein the recruitment process of the concerned post was started prior to January 2005. Despite the order for the single year, it would be appropriate to dispose of this appeal, awaiting the decision of the state government on this issue. It is made clear that if the appellant such and such, please again file such and such. With this observation, I want my repetition to be disposed of with this observation. And I am appointed in the year to 1995-1996, page 18. Your lordship will find. Division bencher, sir. It's in division bencher admitted to the observation.
The short date may be given, Lordship, we will examine and whether it is covered by the division bench judgment or will come
But
before.
Mr. P.K. Roy Chowdhury and the council. You want notice to go? You want to take instructions?
Notice,
Okay,
which week that time may be given.
issue notice. Mr. D. Cycle and Advocate General, assisted by Ms. N. Fuka.
And B. Gogoi, Lordship. B. Gogoi, also finance is also there.
Okay, by N. Fuka, understanding council. Appears for the respondents, 1, 2.
All Lordship, 1, 2, 3, and 4. Either finance or education.
You are both.
Yes, I am both.
Appears on behalf of all the respondents. So, and press for 2 weeks time to receive instructions. Praise the Lord. This after the puja vacation. It has to be after puja.
Oh, I know you.
90 of supplementary person.
May I beg, Lordship? My lord, the petitioner before your lordship is an aspirant for admission into the first year MBBS course of 2024, my lord. And she has qualified in the NEET, my lord, 2024. Your lordship may kindly see page number 32, my lord. Page number 32, annexure 7, my lord.
Yes.
My lord, serial number 4523 on the left side, down below. 4523. Deepshika Das, female, under OBC quota. She secured 432 marks. And securing, my lord, 4523, my lord, state rank, my lord. My lord. And the revised marks, your lordship is aware of the fact that, my lord, with regard to 2024, my lord, NEET, my lord, there was hue and cry across the country, my lord, with regard to leakage of question paper and all these things, my lord. So, the revised mark sheet was issued on 26/7. Next page, my lord, 33. This is the revised mark sheet issued by the respondents to the petitioner, my lord. In the middle, my lord, 26/7/2024. My lord. So I got this revised mark sheet on 26/7/2024. That
Where is the date?
page 33, my lord, date in the middle, my lord, date
Okay,
of
okay.
declaration of result,
Okay.
my lord. But in the meantime, my lord, the respondent issued notice, next page, my lord. Annexure 8, page 34. Page 34, annexure 8, my lord. This notice was issued on 5th June 2024. My lord, inviting the application from the candidates who seek admission under special quota, my lord, to file their special quota claim application before 14 June 2024. Notice was issued on 5th June,
1 minute.
giving the last date of submission of that special quota form before 14 June 2024.
1 minute. Okay.
My lord. But as I got the, my lord, results on 26/7/2024, my mark sheet, my lord, and around 1 month before that, my lord, that notice was issued by the respondent to file the special quota application. Those who are claiming admission under special quota, I belong to the ex-serviceman quota, my lord. But that, my lord,
But then prior to the revised
my lord,
result,
my lord,
you had already got this page 32, isn't it?
my lord. Yes, my lord.
So on this basis, you could have applied for this notice?
Yes, my lord. But because of the reasons, my lord, that I could not file this, my lord, special quota application before the respondent, my lord, I have stated, my lord, at page 12, my lord, paragraph 9, my lord. These are the reasons for which, my lord, I could not submit that special quota application form before the respondent, my lord, which I submitted, my lord, later on, my lord, but that has not been accepted by the respondent. This is my grievance, my lord. Page number 12, my lord, down below, my lord, paragraph 9. Paragraph 9, my lord.
Page number
12.
Oh, 12. Yes.
My lord, paragraph 9, my lord, last part, my lord, down below, that the petitioner submitted the NEET UG 2024 conducted by the National Testing Agency faced severe allegations of question paper link, which caused a hue and cry across the country, and the state of about 23 lakh NEET examinees were uncertain. The results of the said NEET 2024 declared on 4/6/2024 also sparked controversy due to significant increase in the number of top ranks. Many candidates received marks deemed mathematically impossible, leading to huge complaints of irregularities and legal challenges. The situation became further volatile across the length and wide of the country as the students persistently started protests demanding cancellation of the NEET 2024 and holding of re-examination. The Central Board of Investigation, that is CBI, subsequently took over the case number 358/2024 dated 5/5/2024, registered under section so of the Indian Penal Code at Shastrinagar Police Station, Patna, Bihar. The Honorable Apex Code also came to interfere in this serious issue involving around 23 lakh NEET aspirants. With this background, my lord, now I am going to the next para, my lord. In such a volatile situation and uncertainty about the fate of NEET examining of 2024, the young and the poor girl petitioner, that is the present petitioner, my lord, the girl petitioner was sitting helplessly and she was also ill for some days. Furthermore, her present residence is in a remote area where internet connection has also been poor. Additionally, during the relevant period, there was a devastating flood in the district of Karimganj. Because of all these reasons, the petitioner was unaware, ignorant of the notification dated 5/6/2024, issued by the Director of Medical Education, Assam, Guwahati, by which it was directed to NEET UG to submit their special quota application forms seeking admission into MBBS.
Okay, yes, Bora.
My lord.
My lord, at this stage, it cannot be considered because last date was, my lord, last date for submission of form was on 14/6/2024. Accordingly, my lord, the process has started and my lord, the admission is also going on, my lord.
Admission is over or going on?
Over, my lord, it is going on by, but however, my lord, the ground cited by the petitioner for non-submission of the form within the stipulated time, that cannot be considered, my lord, and that cannot be accepted also, my lord. And then also, my lord, even if the petitioner missed the 14 June, immediately thereafter also she did not approve. And as of today, after almost completion of the first round of counseling, my lord, and admission, my lord, at this stage it cannot be considered. If somehow by
Counseling period is over?
the counseling period, first counseling over, my lord, now second round of counseling and
Yes, my lord, the counseling is still continuing, my lord.
and my lord, the representation that petitioner have annexed along with the petition, And she is stating that it has been sent to the director by WhatsApp, my lord.
The
So it cannot-
representation, my lord.
And by some reasons, if she was prevented from filing the application within the stipulated time, immediately she should have approached, my lord. But now, my lord, after the admission has been done in the first counseling, my lord, at this stage it cannot be considered. There is no any tangible ground also, my lord.
My lord,
Because, my lord, it was
On
notified
6
everywhere, my lord.
on 16/8/2024, my lord, after getting, my lord, for verification of the documents, I need to, my lord, to appear before the Director of Medical Education. On 16/8, your lordship may kindly see, my lord, page, my lord, for 39, my lord, 38, my lord. Annex 11, my lord. Immediately after knowing of this, all the development, my lord, I appeared before the Director of Medical Education, Assam, 6 Mile, Khanapara, Guwahati 22, my lord, for submission of the aforesaid, my lord.
When
form.
did you come to know about this notice?
That is not stated by the petitioner, my lord.
Stated, my lord. After knowing of that notice, my lord, then immediately, my lord, I appeared before the,
Where have you stated that you came to know about this notice?
my lord.
That is not specifically stated anywhere in the
Yes,
petition,
yes,
my
my
lord.
lord, page 14, my lord, your lordship may kindly see. Page 14, 1/4, in the middle portion, my lord. The petitioner did not get this communication, that is Annexure 8, and as a result, she could not submit her application form relating to admission seeking under special quota. Your lordship got it, my lord?
Yes.
Thereafter, knowing the developments, the petitioner personally appeared before the office of the Director of Medical Education, Assam, on 16/8/2024. But she was not allowed to submit the form application seeking admission under special quota, ex-serviceman quota.
So that's why this court is asking you one question.
My
When
lord.
did you have knowledge about the notice?
I have stated, my lord, that immediately, as and when, my
When
lord,
did you have knowledge of the notice? On 16/8?
almost, my lord, on 16th or, my lord, just day before 16, my lord. Because,
You
my
come
lord,
with specific answers.
your lordship,
This court is asking a pointed
My lord.
question. You give reply to that question. When did you have knowledge of the notice?
Immediately, my lord, after it came to my knowledge, my lord, I appeared before the director. Your lordship kindly see, the young girl has become, the immediately on 16/8/2024 itself, the petitioner submitted a representation before the director, my lord, for consideration of appeal, stating the facts and circumstances under which the petitioner failed to submit the said application seeking. In the representation requested to allow her submit her special quota form.
You get your instructions properly and come back.
My
In
lord.
any case, the period of time prescribed by that educational notice
My lord.
is over on 14th of June.
My lord.
14th of June to July, July to August, 2 months. After 2 months, you approach the director. That is not.
And then the approach is
And
also by WhatsApp, my lord.
this notice is uploaded in the website,
Yes,
isn't
my
it?
lord, official website of
In the official website. So just because there was a flood, just because there was this hangama about the net examination, would not.
But as my submission before lordship, as the process is still going on, my lord, the process has not been over, my lord.
Process may be still going on, but have you made your application prior pursuant to that notice?
Yes, that another 11 I have.
You have to be also vigilant.
My lord.
You want to get admission into some course,
My lord.
you have to be vigilant about what is going on. Where have you stated when you came to know about the notice? After more than 2 months, you approach the director of medical department.
Medical department.
How can the director help you also? By then the counseling and all were over.
Then I filed the representation on 16/8/2024, my lord, before the director. This kindly may not consider that. And the process is still going on, my lord. The process has not been over, my lord. And sh- and she's a girl belonging to OBC.
She has not filed any representation, my lord. Because the representation that she is referring to, my lord, she is saying that, my lord, it has been sent to the director by WhatsApp of some other persons, my lord. So in this casual manner, my lord,
No, it is not cordial manner, my lord. Actually, my lord, she has a file before the director, my lord.
Did she went and appeared before the director?
My lord.
That's what you said in your pleadings, page 14.
My lord, that the petitioner further submitted that she appeared on 16/8/2024 before the respondent number 3, that is the director of medical education for document verification pursuant to the notice dated 8/8/2024. She got the subsequent notice of 8/8/2024 subsequently, my lord. And having my lord that knowledge, she was she went to the office of the director, but she was not allowed to get
That we have
document
read,
verification.
that we have read. You get instructions properly and come back. Not this as, otherwise we can dispose of directing the director if the petitioner has made a representation to consider that. representation.
Then, my lord, then your lordship may kindly direct the director to, my lord, dispose of the
But
representation.
Have you submitted your representation?
No, my lord, there is nothing submitted.
Have you submitted your representation?
This annexure even may kindly be considered as representation, my lord. Though it is.
Whether the directors got this representation? We list it on Friday, you come back properly. Well, there are many cases.
My lord.
You can't delay the
My
court
lord.
because of your case. Mr. A.R. Talukal and the counsel for the petitioner shall receive appropriate instructions, shall receive instructions as to on which date the petitioner came to know about the educational notice dated. What date is this?
5/6.
8/8. No.
5/6/2024, my lord.
2024.
Educational notice
At page 34.
dated 5/6/2024. Stop. List on 20.
Obligation.
God bless.
91 and 92 of supplementary list order.
The other day, I have basically placed all the facts. Now I would like to place the judgments which I am relying lordship. So my first submission would be lordship as because 2 rounds of litigations were there. In one which is still pending, their whole contention was that they were appointed under 3F and they want regularization. There was no prayer for giving any additional preference or marks in response in relation to their past services. And in the other case, they have challenged the recruitment notice of April 2023, which laid down the procedures. And along with that, the earlier round of litigation, there is a challenge to the advertisement also. And subsequently also in the second, which lordship was pleased to dispose of, they have challenged the advertisement also, that nothing should proceed on the basis of the advertisement of February 2023. So there was absolutely no prayer relating to lordship that grant of marks. So they are basically aggrieved by the observations given by this honorable court in the judgment in paragraph 45. Where lordship was pleased to express an opinion that although they are entitled to get past services preference, but as they have already participated in the MQR and MMR test, they are not entitled to get that preference. while upholding the advertisement of February 2023 and interfering with the four notices, the notices, recruitment notices of April 2023. So paragraph 18 is the bone of contention now.
Which page was it?
Page 45, Lord. And two other writ petitions, the writ petitions number 3048, in which this judgment was delivered. The prayer was to set aside the recruitment notice of 23. We have a written submission if it is convicted. Yes. If Lordship is pleased to take up my written submission. So the prayer in WPC 3048 is to set aside the recruitment notice of 23rd April 2023. Direct the authority to cancel, recall, or forbear from giving effect to the recruitment notice of 23/4/2023, and direct the authorities not to proceed with the recruitment process pursuant to the advertisement of 21/2/2023. In response to these three prayers, Lordship was pleased to set aside, grant them allow the writ petitions in respect of prayer number A and B. That is setting aside the recruitment notice of 23rd April 2023. However, Lordship was pleased to direct the state government to proceed with the advertisement dated 21/2/2023 in strict terms and conditions as stipulated in the said advertisement. So now they have come before this honorable court to say that they are entitled for getting special preference for their past services, which was number one, not the subject matter, number one, and number two, in either of these two notices, that is not a term and condition. What they are trying to seek from this review petition is that they want something additional which is not considered by the courts below, at the first round of litigation, one of which is still pending, that is not the subject matter. What is their prayer? In response of the case which is still pending, that they entered service under 3F of the regulation of 1951 of APSC, Lordship, which is basically giving them the employment for 4 months period, which was subsequently extended from time to time. So they want regularization of their 3F appointment. That is their prayer. And in that prayer, the Honorable Court passed an order, which is a part of the records now, that we can proceed with the recruitment, we can issue the appointment. However, any appointment made pursuant to the said advertisement of February 2023, it will be subject to final outcome of the writ proceedings. So that is still pending, yet to be finally decided. Although the law is well settled that 3F appointee cannot be regularized. That is the well settled law for last 3 decades in this honorable court, at the highest level also. In fact, the 3F is very clear. The regulation 3F is very clear that it is for temporary 4 months period when there is some urgency. The government wants some recruitment, some persons on the post. So to get over in lieu of a regular recruitment process, which consumes much longer time, that option can be adopted by the government department and agencies. So now what they are praying, what they are seeking from paragraph 18, where I'd like to read out the last 5 lines. Therefore, in the considered opinion of this court, the past services of the petitioner should be counted. That is an opinion expressed by this honorable court. Although it was not paid, but while deliberating with the judgment, Lordship give that opinion. However, considering the fact that the petitioner in both the petitioners have already participated in OMR MCQ-based written examinations without any protest, this court is not inclined to interfere in all the 4 notices dated 21/2/2023. So, Lordship, although gave him an opinion that if had they prayed, Lordship would have directed. But they did not pray. But it was an opinion, passing opinion, that on the basis of which they cannot make any or no right has been accrued to them at this stage. However, Lordship upheld the advertisement of 21st of February 2023, which laid down, and there's a direction also. Paragraph 20. If the review prayer is allowed, then it will be directly in conflict with paragraph 20. May I read to paragraph 20? Accordingly, the recruitment notice dated 23/4/2023 is set aside and quashed. The respondents are directed to proceed with the recruitment process strictly. Lordship will kindly note this word, strictly. In terms of the conditions laid down in the notices dated 21/2/2023 for recruitment to the 61 posts of assistant professor and 46 posts of assistant professors non-technical in government engineering colleges of Assam, as well as for recruitment to the post of 80 posts of lecturer technical and 57 posts of lecturer non-technical in the government polytechnics. So Lordship directed us that you proceed as per the advertisement, recruitment advertisement, Lordship, of 21st of February 2023. Strictly in the terms and conditions as laid down. Now, what they are trying, whatever was not there or not challenged in the advertisement, as well as the recruitment notice, they are praying beyond which is not contemplated in those notices also. Neither those conditions or terms, if at all it was there, was challenged, nor it was argued. By means of this review application, they are seeking something which is not there in their original prayers. They are seeking something from the moon now. So, my humble submission is that suppose their prayer is to be considered, will it not amount to Lordship changing the rules of the games after the game is almost over now? The interview is also over as per their submission on 11th of September. The first round of that is for the this written test, they appeared long time back before the judgment itself. So the game was started long time back because they could not get any favorable or because in batches they come before this honorable court. The same batches who were recruited in 2021 under 3F. Few come before to this proceedings. The other few came to the other proceedings. So they have decided that some different groups will come before this honorable court seeking different prayers. But none of the prayers says that we want additional marks or additional preference in respect of our past services. So, yes, and if that has to be done, suppose this review is allowed, assuming that review is allowed, we have to rewrite the advertisement. New people will come, all these things, it will create a topsy-turvy situation. So, in response to this, Lordship, I would like to place a judgment. Yeah. First is that if there is no prayer in a writ proceeding, then what the honorable court normally do? This honorable court has definitely power to mold the relief. But the duty cast upon them, the author of the writ petition, to make that prayer in the writ petition. This is 2010 1 SCC volume 234, Bharat Amratlal Kothari versus Josu Khan, Samadhan Sindhi and others. Paragraph, Lordship, the citation will be 2010 1 SCC page 234. I would like to rely upon paragraph 29, 30, 31 up to 35, 4, 33.
Learned AG, this is not readable at all. Get a different copy.
Oh. Lordship will take this. We give proper printouts.
Sure.
May I read it, Lordship? The approach.
From bar we have taken.
We have just got the printout from me. Anyway, Lordship, we'll get proper printouts also.
Okay. Para?
Paragraph 29, 30, 31, 32, 33.
Yeah.
May I read it, Lordship? Paragraph 29. The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all reliefs. Under the provisions of the Code of Civil Procedure 1908, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the codes are not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the Civil Procedure Code will apply only even to writ petition. It is therefore incumbent on the petitioners to claim all relief he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot ignore and keeping aside the norms and principles governing grant of relief, granting a relief not even prayed for by the petitioner. In Krishna Priya so-and-so case, overlooking the rule relating to grant of admission to postgraduate courses in medical colleges, the High Court, in the exercise of power under 226 of the Constitution, directed the Medical Council to grant provisional admission to the petitioner. This court set aside the order passed by the High Court, observing that in his own petition in the High Court, the respondent had merely prayed for a writ directing the state or the college to consider the case for admission, yet the High Court went a step further and straightway issued a writ of mandamus directing the college to admit him to the MS course and thus granted a relief to the respondent, which he himself never prayed for and could not have prayed for. Again, in Om Prakash so-and-so, a party be granted a relief which is not claimed if the circumstances of the case are such that the granting of such relief would result in serious prejudice to the interested party and deprive him of the valuable rights under the statute. Pausing here for a moment, Lordship, my submission is that if suppose the additional marks is given to them now, that will deprive or that will cause prejudice those to the other persons who are participating in the recruitment proceedings under the same rules and regulations. So this will create a prejudicial situation to the other persons who are not getting this benefit. Because at the beginning, that benefit was never contemplated. 33. Though a High Court has power to mold reliefs to meet the requirements of each case, that does not mean that the draftments of a writ petition should not apply his mind to the proper relief which should have been asked for and throw the entire burden of it upon the court. So they themselves, on one hand, they are challenging the advertisement of February 2023 at the recruitment notice of April 2023. Now, Lordship set aside one part, the other part is still valid as held by this honorable court. They want that advertise should be also tinkered with by adding that recruitment process will also allow them to get additional marks. So they want to change the rules of the games now in respect of their own interests. So this is one judgment regarding if the prayer is not made, Lordship, that prayer normally, this honorable court has definitely power to mold the relief. But in a review application, in my humble submission, that power is not there. Had it been at the first instance in the writ proceedings, definitely Lordship, if there was a proper argument, proper prayer, Lordship would have considered. But in a review, Lordship, that is not, because that is beyond the scope. What is a review all for? If there should be an error apparent on the face of record, a prayer which was not made, how can it be a part of the proceedings? There cannot be any error, this side or that side, because that was not the subject matter. The subject matter was deliberated before this honorable court. Whether the advertisement was correct or incorrect, whether the recruitment notice was correct, valid or invalid. Not the issue was not that whether they should be entitled to get past services preference or not. That was not the argument point. That was not an issue. So
No, that was also argued. That was also argued.
Lordship, that was not prayed. We must.
No. Prayer portion, that's a different thing. But that was also argued.
How can it be? If suppose they are arguing in the course of oral arguments, they can do, but they must have a basis. They must have a prayer. Where is the prayer? They have quoted one paragraph. What they are doing, Lordship, on one hand, they say the advertisement is wrong. The other one, at the same time, they wanted the advertisement should be modified. So you cannot play both. Now, If suppose that is argued and Lordship was pleased to wrote the authored this judgment at paragraph 18 as well as paragraph 20, how it can be reconciled now? 18 and 20. In 18, Lordship given an opinion but denied them that prayer, if at all it was made. However, in 20, Lordship said that in strict terms and conditions of the advertisement of February 2023, we have to complete the recruitment process. Now, I would like to place another judgment. Yeah, please hold on to tell it. It would know, it would know. Yeah, please hold on. Okay. Okay. Yes. The judgment is 2008. Volume 3 SCC, page 512. Itu judgment court আছে এইটো judgment to illegible. Is it readable, Lordship?
This is
Slightly better.
slightly better. Para?
Paragraph, Lordship, 27 and paragraph 32, two paragraphs. 27, may I read, Lordship? The in between, place it term C. Therefore, Therefore, introduction of the requirement of minimum marks for interview after the entire selection process consisting of written examination and interview was completed. In our case also, identical situation would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified with this view by several decisions of this court. It is sufficient to refer to 3 P.K. Ramachandra, Umesh Chandra Sukla, and Durgacharan Mishra. So paragraph 32. Another judgment which is in Maharashtra, STRC versus Rajendra Bhimrao Madhve, this court observed that the rules of the games, meaning thereby that the criteria for selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. In this case, the position is much more serious. Here, not only the rules of the games were changed, but they were changed after the game has been played and the results of the game were being awaited. This is unacceptable and impermissible. At the very beginning, before the written test, if that prayer to a proper repetition comes, Lordship would have definitely considered that prayer. But that should have taken place prior to the written test. Once the game has commenced, the rules cannot be changed. That is a settled position of law. Number of cases of the Supreme Court and this Honorable Court also number of times either laid down the law or reiterated the law laid down by the Honorable Supreme Court. So the game cannot be the rules cannot be changed once the game has started. So these two judgments, apart from that, I would like to place 1 or 2 judgments relating in a review. 2022 SCC Online Supreme Court 1034. Yes. Lordship, I would like to refer to, Lordship, mark the paragraph. I would like to read 1 or 2 paragraphs because there are several paragraphs here. 16, 17, 18. 16, 17, 18, 19, 20, 21. 21 within bracket 56 and 58. Then paragraph 23, 24, 30, 31. I would like to read paragraph 24. After discussing paragraph 24, Lordship, after discussing a series of decisions on review jurisdiction in Kamlesh Verma versus Mayabati, this court observed that a review proceedings have to be strictly confined to the scope and ambit of Order 47 Rule 1 CPC, as long as the point sought to be raised in the review application has already been dealt with and answered. Parties are not entitled to challenge the impugned judgment only because an alternative view is possible. the principle for exercising review jurisdiction were succinctly summarized and captioned below. Pausing here for a moment before going ahead. They might have argued that they are entitled for past services experience marks. And Lordship has denied that. Two views are possible. Lordship could have allowed that also. But Lordship has denied that. Whether that is a error apparent on the face of record. So two views were possible. Lordship denied. Lordship took one view. Now they want to change Lordship's view now by this review application. That, in my humble submission, cannot come under the purview of a review jurisdiction. It can be well argued before a appellate forum. I'm continuing, Lordship. The principles for exercising review jurisdiction were succinctly summarized in the caption case as below. Thus, in view of the above, the following grounds for review are maintainable and stipulated by the statute. 20.1. When the review will be maintainable, discovery of new and important matter of evidence, which after exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him. He is not covered by 1. 2. Mistake or error apparent on the face of record. That is also not there. Any other sufficient reason. The word any other sufficient reason has been interpreted in Sajuram versus so-and-so and approved by this court in Moran Mar Catholics case to mean that a reason sufficient on ground at least analogous to those specified in the rule. The same principle has been related by Union of India in Sandur Manganese and Oil Ores Limited case. When the review will not be maintainable, a repetition of the old and overruled argument is not enough to reopen concluded adjudication. They are coming under this. They argued and they failed to get a favorable order. So a repetition of the old and overruled arguments. That argument was already made. It has just now Lordship has said that they argued. Although it was not paid, but during the course of writ proceeding, they argued. If that is the case, Lordship, then they will squarely covered by 20.2.1. A repetition of old and overruled argument is not enough to reopen concluded adjudication. Minor mistakes of inconsequential import. Review proceedings cannot be equated with the original hearing of the case. Review is not maintainable unless the material error manifest on the face of the order undermines its soundness and or results in miscarriage of justice. The review is also by no means of appeal in disguise whereby an erroneous decision is reheard and corrected, but lies only with the patent error. Now, coming to Roman 4 again, review is not maintainable unless the material error manifests on the face of the order undermines its soundness or results of miscarriage of justice. Lordship has denied their prayer with a reason. It is not that Lordship has blindly and mechanically passed that order. What Lordship has held, that they are not entitled to get this benefit of past services experience marks because they, without any protest or with protest, participated in the first phase of the selection process. What was that? Sitting in the written test. So that is the reason given by this honorable court that you have already accepted the advertisement, accepted the procedure of selection, you participated in the written test. Now you are saying that you need more marks in the interview. That's why little while ago I made a submission, and had it been at the very beginning, before the process started, advertisement was issued, recruitment notice was issued. At that point of time, they could have got a clarification either from the department or from this honorable court, whether in the interview additional marks will be given to them or not for their past services. That was a very important issue they could have raised at the relevant point of time. Now my humble submission, there is a delay and latches in that regard. So for that also, they are not entitled to get any relief. That delay is fatal here. The department as well as this honorable court allowed us and directed us to proceed as per the laid down rules and norms for the recruitment process, paragraph 20. So that delay and latches also is paramount importance so far as their review prayer is concerned. Going further, 6. The mere possibility of two views on the subject cannot be a ground for review. I'm repeating again. Lordship could have given them or Lordship could have rejected them. Lordship have rejected them. Their prayer is rejected. Their prayer is not considered to be maintainable or acceptable to this honorable court. Now they want reversal. What they want, that they should get the additional marks. And Lordship has denied them. So the mere possibility of two views, that's why I'm submitting. Two views are possible. Lordship has taken one view. The mere possibility of two views on the subject cannot be a ground for review. Error apparent on the face of record should not be an error which has to be fished out and searched. I said long arguments had to take place in these proceedings. That is not the scope for review. It should be prima facie evident that the mistake has taken place. If the mistake is crept in, Lordship, it should be visible prima facie. For that, long drawn arguments is not required. But here we are arguing that itself is a proof that this is not a fit case for review. It may be a fit case for appeal. Number 8, the appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negativated. Again, number 9 also covers their case. It has been negativated by this honorable court, their prayer. Now they want a positive order. They want the opposite of whatever opinion this honorable court has expressed. So I don't think, Lordship, I have anything more to submit except just giving a reference to another judgment. 2023 Supreme Court Online SC, page 185. As Murali Sundaram versus Jyothibhai Kannan and others. Paragraph 15, 1-5.
Yes.
Paragraph 15. While considering the aforesaid issue, two decisions of this court on Order 47 Rule 1, read with Section 114 CPC, are required to be referred to. In the case of Peri Kansagra, this court has observed that while exercising the review jurisdiction in an application under Order 47 Rule 1, read with Section 114 of CPC, the review court does not sit in appeal over its own order. It is observed that a rehearing of the matter is impermissible in law. It is further observed that review is not appeal in disguise. It is observed that power of review can be exercised for correction of a mistake, but not to substitute a view. This covers our situation. Lordship has already taken a view. Such power can be exercised within the limits of the statute dealing with the exercise of power. It is further observed that it is wholly unjustified and exhibits a tendency to rewrite a judgment by which the controversy has been finally decided. After considering catena of decisions on exercise of review power and principles relating to exercise of review jurisdiction under Order 47 Rule 1 CPC, this court had summed up as under. A review proceedings are not by way of appeal, but have to be strictly confined to the scope and ambit of Order 47 Rule 1. Power of review may be exercised when some mistake or error apparent on the face of record is found, but error on the face of record must be such an error which must strike one on mere looking at the record. That is prima facie, and would not require any long-drawn process of reasoning on the point where there may conceivably by two opinions. Power of review may not be exercised on the ground that the decision was erroneous on merit. Power of review can also be exercised for such other sufficient reasons which is wide enough to include a misconception of fact or law by a court or even by an advocate. This is that Netaji Subhas case of 2005, BCCI's case, from that this line is taken. An application for review may be necessitated by way of invoking the doctrines of extra curi nebimam gravita. That means no one should be caused any prejudice. So that is the principle. So this principle clearly indicates that the fact situations which is now a part of the review proceedings, Lordship, that situation does not permit or allow this honorable court, or this honorable court would like to enter into the jurisdiction of review to grant them any relief. This is a fit case in my humble submission that review this petition deserves dismissal. This is my humble submission, highly obliged.
The other day, my lord, my senior has already placed our argument. I just want to add one line. In paragraph 18, your lordship has given two findings. In my humble submission, one finding is that your lordship has opined that this is not only an opinion, this is, in my humble submission, this is an affirmative finding that after discussing the regulation of AICT regulation, your lordship has come to the finding that past services of the petitioner should be counted. And the next finding is that since we have not protested and we have participated, therefore your lordship was not inclined to set it aside the advertisement. This is not our prayer, as well as in our petition was not structured that there is the validity of advertisement is not under challenge in this writ proceeding. Therefore, in my humble submission, this is the error where cropped up while coming to a finding that your lordship would not like to set aside the advertisement. So rest I leave it to your lordship.
Okay. When are you finalizing the matter?
We are actually running out of time. That's why instead of 28th of September, we finish it by 11th. So maybe 10-15 days.
10-15 days you take. Today's Monday. Okay, Friday I'll give the check.
Deeply obliged.
Friday get it.
Well, we have not seeking any additional benefit under this review.
No, fine.
Obliged.
But lead us and senior counsel assisted by
It's
Mr. H. For the review petitioner. Also heard Mr. D. Cycle and Advocate General Assam, assisted by Mr. K. Gupta. Understanding of the higher commission, having convened of the testimony. Friday I'll pronounce lordship. That's 5 minutes.
No? What?
69.
These three items, my lord, this was the interim order. Lordship can pass this order like that, my lord. This order, first Arjun Das case passed, my lord.
Oh, yes,
Only by
Arjun Das
provisional
case.
admission, subject to result of the petition. Their admission, subject to result of the petition. Our portal will be direct council to open the portal for 2 days. Within 2 days, they will apply.
Yes, my lord.
And
Yes.
they will verify all these things, my lord. This is the, apart from that, my lord, this should be the last lordship's order, my lord, because we are preparing now for examination. We cannot, my lord, open more days for the, my lord, admission. That has been.
No, item.
Item, my lord, 65, KDB case 65.
My case, my lord.
67 and 69.
65.
67 and 69. Why not?
Yes.
Yes, my lord.
And how about 66 and 68?
66 and 67, there is another order, my lord. This order was passed in the IA. This petitioner passed the IA, the interim order is passed, my lord. He annexed the order, my lord. Lordship, can you see item number?
66 and
66. Last
Only-
paragraph, Lordship, 26.
Item 66.
Yes.
Also 1 to 6.
My lord, on 7/8/2024, Lordship's order. Herein, my lord, IA, this order was passed in a IA. Now, whether petitioner is agreed to dispose of it or not, well, I don't know. If Lordship, he agreed to dispose of it, Lordship can dispose of it. Dispose of.
Yes, man, can be disposed of.
No, who is the IA order in the IA?
IA is not there.
IA
Any
for, my lord,
petition is, my lord.
Portal, man.
His case, in a
Itu I need.
66 and 68.
68.
This interim order, Lordship, is 54.
1 minute. I'm not getting you.
Is item 66, my lord.
Item number 66 and 68.
4126, WC 4126. There is an IA, my lord, and the my lord, portal was open as per my lord order dated 7/8/2024, passed in IA. The notice was issued for provincialization of their school, my lord. Subsequently, they filed and my lord, IA for allowing them to my lord, for admission of the higher secondary first year classes. So the order was passed in the IA. That is page my lord 54, my lord.
There is a direction, lordship,
Page 54.
54. There's because why this order is passed, my lord, they have said they are in their case, the government has approved it. That is the conditional approval. That's why lordship directed to verify all these things and whether they are eligible or not. If eligible, then they will do it. And if it is not eligible, they will pass an order. That is the order. And this should not be a precedent, my lord, because we are now preparing for examination. This may be the last order from your lordship, my lord, because this case are pending. That's why.
No, 1 minute. That means there are two different cases.
Two different cases. There will be this.
Let us first deal with KDV.
KDB case.
Yes.
Here, notice has all have.
The file affidavit also, my lord.
So you want this
This case should be pending because the interim order says this interim order shall subject to result of the writ petition. That's why
Outcome
KDB
of the
case
writ
should be
petition.
continued. KDB case should be pending.
Okay. In all the writ petitions.
No, three petitions.
Three
No,
petitions.
that's why in all
Yeah,
the three
yeah.
writ petitions.
Same order.
Same order.
Same order.
Same.
Yes, my lord.
This
Instead,
same order.
instead of school authorities, my lord, maybe directed respondents, my lord, because school authorities, otherwise we are not the school authorities. School authority means the headmaster.
Okay, heard MS K. Devi, Learned Counsel for the petition, as well as Mr. T.C. Tutor, Learned Standing Counsel, AHSC. Stop. Have you filed your affidavit?
We have filed affidavit.
Yeah. You file your reply?
No, my lord. No, not necessary.
You want to go for a hearing?
Yes, my lord. Like similarly situated case.
No, only today for interim, my lord.
No, that's why.
Yes.
You want to go for a hearing on a different day?
Different
Different
days.
day.
Yes, my lord.
Only-
It mean, your lordship has passed an order to file affidavit from the government. Government means addiction department, secondary. They are not going to file till yet. In another case.
Today only for interim. Interim order.
No, you want
After
time for
petition, my
filing
lord,
your,
all the
filing
cases
your
may be instead-
objection?
Mm.
You want to file your,
Today we have come for interim to open the
No, no.
portal only.
then you heard MSK Devi, Learned Counsel for the petitioner. The HSSC, who is represented by Mr. T.C. Chukia, has filed counter affidavit. Mr. B. Kaushik, Learned Standing Counsel, Secondary Education. Place for how much time? 2 weeks? 2 weeks time to file counter affidavit. Praise allowed. List after puja.
Yes,
List after the puja vacation. Para. In the interim, comma, the respondents are directed to permit the petitioner schools to give provisional admission
yes, my lord.
to the students of class
11.
11
Session 24.
for the
Two to
session
25.
2024-2025. Stop. However, comma, such admissions shall be subject to the outcome of the writ petition. Stop. The respondents number,
We are for 7 and 8.
so you'll be the one who will be opening the
Yes,
portal.
Yes,
as
yes.
we will open, my lord.
They will open.
The respondents 7 and 8 are also directed to keep the portal within inverted comma, you say Darban in capital,
Darpan.
open till
2 days, my lord, only two days.
This is difficult, my lord.
No.
They are from,
That may be given.
someone is not Lakhimpur, someone is
3
Karbi
days,
Anglong.
3 days, 3 days.
Within a period of 1 week, my lord, for the sake of the student. Right?
Today is Monday, we'll say 20, Friday,
No.
up to Friday.
Up to Friday, yes, my lord.
The last.
Last.
Till 29, 2024.
And
That is one order.
so far,
1 minute. And item 67. 4140.
67 and 69, my lord,
1 minute.
are similar.
Here it's respondent 5 and 6, isn't it?
Yes, somewhere.
It will be the same thing.
Yes, only respondents are different.
The respond in the end of turn, the respond number 5 and 6.
5 and 6.
Are directed to keep the portal open, no? Still it's 20.
my lord, it may be noted, my lord, it may be mentioned, my lord. After 20, my lord, portal will be opened.
My lord, I have filed 1 cases today itself. Of course, then
No,
it
no,
will
my
come.
lord,
1 minute.
no more, my lord. We will not accept it.
See, how to
yes.
prevent? How to prevent? You
Okay,
cannot
then-
prevent like this.
then
He
we'll
won't be
file
able
a
to submit like this, my lord.
If you have to get your admission, you'll have to do it within the time limit.
Yes, within this week, my
this
lord. Yes,
court
yes.
is giving.
No, I have already filed the case. It will come on Wednesday. এখন school মাত্র।
It is made clear that the portal
Don't deprive us like
shall
that.
not be open beyond the date fixed by this.
He justice.
I'm saying it is made clear that the portal shall not be open beyond the date fixed by this.
Yes, yes.
Yes.
Okay,
Hello,
this
bless.
item 1 minute.
Item, Kayum item, my lord.
66 minutes.
69, 1 minute, 69,
66.
4, 5.
9 years, my lord.
Kayum 66 and
1 minute, 4, 5, 4, 9. Is also same.
Kitang মাতিব লাগিব।
it may be disposed of, my lord. Interim order is
1 minute. Here's respondent 6 and 7.
6 and 7. In 69.
So 65, 67 and 69. all
Yes, similar.
Separate orders.
yes, yes.
Or what is it? List after the puja vacation. And then the next case,
66
Kayam, your
66
case
million.
66 is 4126.
Yes, my lord.
and 68.
126. In this case, my lord, item 66, my lord, notice already issued, my lord.
Yeah.
The interim, my lord, my lord, portal may be, my lord, kept open till 20th of September. That is space 54 million.
You want to dispose of it?
মানে একটু পেন্ডিং আছে পোর্টালটো ওপেন কৰি হ'ল
Page
page 54 million the water visit million it was passed on million the IA
you file your affidavit here.
We file a verification.
Kaushik, you want to file affidavit?
They have not filed.
We have not filed.
So you want to file? Okay, then I'll pass the same order then.
Same order, my lord, they will verify it. And we,
Oh, okay, 1 minute. Item 66. Heard Mr. D.A. Kayu, learned counsel for the petition. The AHSCC, who is represented by Mr. T.C. today, has filed contrary affidavit. In all you file, in all you
yes,
file.
we have filed. In Kayum case 1, we have filed. It will go.
Mr. D. Kayu, Mr. B. Kaushik, then a standing counsel, secondary education, placed for 2 weeks' time to file contrary affidavit. Place allowed, please up to the puja vacation. Stop. After hearing the parties and by way of entry, the authorities in the Assam Higher Secondary Education Council are directed to keep the on top within inverted commas, that one portal. Open till, it will be the same date,
Same date,
29,
20 September 2000.
stop. The petitions are also directed to approach the authorities in the Assam Higher Secondary Education Council. On or before?
On or before, because 20 is the last date.
Yes.
So before my lord, 17 months. 18, 18 months.
On or before 18th of September
Because they'll have to verify.
2024 by submitting all relevant documents for verification of the same by the ASHEC authorities. Stop.
Thereafter,
Thereafter, comma, the AHSC shall verify the documents and pass appropriate orders for their eligibility to get admission in the said portal. Stop. It is made clear that the portal Darpan shall not be opened beyond 29, 2024. In that, it'll be the same.
Same.
No respondent numbers
Yes,
given. no?
yes.
We can play, it's safe to pass the same.
In this case, Miller, notice was not issued. It is a motion case, Miller, but the notice may be issued.
Which one?
Item number, Miller, 68.
Item 68 is
See, 4328. The petition number 4328.
4328. Where's that number? Yeah, 4328. What is this? 432. What is this? This is an I. Your notice not issued.
No, Miller.
No, I have two files, 432.
It is the application number. Name of the party, Miller, Patamari Sonaram SS School. Patamari Sonaram SS School. Sonaram.
One is Ranu Shom. What is this? Ranu Shom. Oh. Oh. Four three two eight of 2022. Okay, of 2024. From where it is coming? Hmm? Okay, we step with items.
Yeah, we respond number 4 and 5 madam, in this case. Council.
Okay, heard Mr. T. A. Kayul and the council for the petition. Issue notice. Mr. B. Kaushik, Learner Standing Council Secondary Education. Appears for respondents 1, 2, 3. And Mr. DCJ, Tutor, Learner Standing Council is AHSC appears for the respondents 4 and 5.
4 and 5.
Extra copies you prefer.
Yes, thank you.
Respondents under the file affidavit. List up to the puja vacation. Then the same entry. Same entry model.
Same entry model.
Oblige.
Oblige, madam.
Day of daily list motion.
After the this honorable court order, GLC considered the case of 3 times, but 3 times that has rejected.
Where are the minutes?
Minute judgment level.
Now the picture has changed. You'll have to challenge this minute.
Your Lordship, the thing is, the petitioner has made a representation on 6/5/2024. The same has not been answered to. She has made the entire scenario very clear to the
No, 1 minute.
I have marked the all minutes.
Which one?
That is marked yellow mark.
Hmm?
Yellow and red mark, my lord.
Flag.
Not flag, my lord.
Yellow.
A particular point by yellowing.
When was this DLC? 9/8/2021.
First one, my lord.
First one.
Yes.
This is
First one, 9/8/2019.
okay.
Second one is 9/8/2021. Third one, 14/2/2022.
9/8/2021
Hmm.
and
14/2/2022.
14/2/2022. On what grounds? Your case has been placed before the DLC on 3 occasions after the judgment passed by this court.
Lordship may kindly turn to page 50 of the petition. We have annexed a representation where she has informed the Deputy Commissioner Nogam, who is the chairman. On various occasions, she has been there in their office, and it has been made very clear in the application that nothing has been informed to her till date. And
So now the council has come with this. You furnish him a copy.
now,
Then after that, there'll be a separate course of action for you.
Lordship, the DLC meeting will be held on 19th.
That is a different thing now. Now you have already been rejected. Now you have to challenge the DLC minus. Forget the coming DLC. They are not going to consider the matter. Have you seen the minutes?
No, Lordship, it has not been furnished to us.
Furnish the copy.
We have no knowledge of the same. And Lordship, since 2024, they have made a representation. It was not been answered with. That is the reason why we have approached this honorable court.
Now that he has come with the instructions.
Now, Lordship, the DLC meeting will be held on 19th.
That's a different thing now. This makes no sense. It don't make any difference for you.
So application can be considered this time. It can be put this time.
Cannot be. Have you read the language of the DLC, the manner in which the DLC has rejected your case in these 3 occasions?
Nine times to 12 minute consideration. Prior to quota that 6 minutes, after minute again.
You give him, furnish him a copy. If he wants to withdraw and file afresh, that's a different thing. Otherwise, since the DLC minus is not under challenge, I'll have to dismiss this with petition. That's all.
If something can be done, because Lordship, since 2016, she has been going to the office, and now she has no idea about the 2021 and 22 DLC meetings. She made an application. She has not been answered with. So we have approached this honorable court, and this minus has been placed today, and DLC meeting is going to be held on this month. So, Lordship, if
why are we having a fixed focus?
Yes, Lordship.
When things are changing, you have to change your argument. DLC has considered your case 3 times. Last occasion was 2022.
If they would have answered to our representation, we would have challenged this.
No, regarding.
So that's why now that the minutes are before you, it's up to you now. What do you want to do?
Now we need to go through the minus first, Your Lordship. Then
Okay. Mr.
Yes, Honorable.
Illinois Counsel for the Petitioner. Mr. P. Cycle and Government Advocate submits that the concerned district level committee, the concerned district level committee has considered the case of the petitioner on 9/8/2019, comma
9/8/2021.
9/8/2021
14 to 2022.
and 14 to 2022. After the order dated 31/7/2019 was passed by this court in WBC number 4371 of 2016. Stop. He has also produced the minutes of the DLC, which held its meeting on the aforesaid 3 dates. Stop. The same is placed on record. I'm placing it on record, this one. Stop. Mr. S. Ahmed, Learned Counsel for the petitioner. How much time you require?
1 week.
Press for week's time to enable him to receive instructions. Press allowed, list after 1 week.
Public.
5.
Lord, I was supposed to obtain instructions. Lord, I have received instruction, my Lord. My Lord, the principal of University Law College and the teachers concerned are not, have not consented to hold any separate examination for the writ petitioner.
What is it?
My Lord, sessional examination, my Lord. My Lord, I take your lordship straight to page 31. The clause
26.5.
26.5.
Yes.
If a student misses any of the sessional examination for valid reasons, as evidenced by medical certificate or other authentic documents, it is important. The teachers concerned may allow the student a separate examination using the teacher's own discretion.
Correct.
Now, 26.2.
26.2.
Above that. The principal, in consultation with the teachers, will notify from time to time the exact dates of sessional examinations, viva voce, and group discussion seminars. So, my lord, the principal as well as the teachers concerned, my lord, they will fix the date. That if they are agreed that a separate examination would be required to be held. Now,
No, 26.2 is with regard to the normal sessional examination.
Normal, my lord.
Okay.
It is exception.
Now,
But 26.5
Is an exception.
is an exception
Exception.
where the student cannot appear in that particular semester examination. Then the teacher concerned
my lord,
may allow the student to have a separate exam.
may allow. Now,
That's all.
kindly turn to page 33. Two clauses. That will clarify the entire scenario. Clause 33 and 34. No betterment and back paper shall be allowed in the internal assessment. It includes that sessional examination, internal assessment, and in practical clinical papers in any semester. Now, 34. A candidate must pass all his or her semester examination, including the back and betterment chances, within 5 years in 3 years law course from the date of admission to the first semester. A candidate will get a maximum of 3 chances to clear a particular semester. Be it clarified that a candidate not appearing in any examination due shall lose the particular chance allowed to him or her. My lord, these two clauses, my lord.
1 minute. Yes.
There would be no back paper regarding that sessional examination, and there would be 3 chances up to the my lord, for a period of 5 years for 3 years LLB course. Now kindly turn to page 11.
Page?
Page 11, paragraph 11. Writ petition. Their contention.
1 minute. Page 11.
11, paragraph 11.
Yes.
May I read, my lord? Let the petitioner begs to state that as per regulation 26.5, the concerned teacher may allow the student a separate examination using the teacher's own discretion if a student misses any of the sessional examinations for valid reasons, as evidenced by the medical certificate or other authentic documents. It is important. In the instant case of the petitioner, though the concerned teacher showed interest, this must, my lord, showed interest to allow the petitioner for a separate examination,
But without approval of the principal of the college, they are also reluctant to take separate examination for the aforesaid 2 papers of second semester sessional examination, and the principal of the college did not allow the concerned teachers to take separate examinations of those 2 papers, nor she allowed the petitioner to give separate examination of second semester sessional examination. Now, paragraph 15. Regarding Miller showing of interest. Paragraph 15, page 13, Miller. That the petitioner begs to submit that as per regulation 26.5, the concerned teacher may allow the student a separate examination using the teacher's own discretion if a student misses any of the sessional examinations for valid reasons as evidenced by medical certificate or other authentic documents. In the instant case of the petitioner, though the concerned teacher showed interest, it is important, Miller, showed interest to allow the petitioner for a separate examination, but without approval of the principal of the college, they are also reluctant to take separate examination for the aforesaid 2 papers of second semester sessional examination, and the principal of the college did not allow the concerned teachers to take separate examinations of those 2 papers, nor she allowed the petitioner to give separate examination of second semester sessional examination. We can skip other Miller sentences, Miller. Miller, sum and substance of these 2 paragraphs is there. The teachers concerned showed interest, but not consented, Miller. There's no any document, Miller. And in fact, Miller, my instruction is that the principal as well as the teachers concerned have not consented to Miller hold any separate examination.
Why?
Miller, since Miller, the writ petitioner will get 3 more chances, and Miller, the examination will be held in February and April next year. So, Miller, he will have a chance to appear in those examinations. So, Miller, as per 26.5, it is not mandatory, Miller. It is the discretion of the teachers concerned, as well as per 26.2, the principal concerned. They will jointly, Miller, take decision regarding holding of separate examination, but they are reluctant to do so. So, the writ petitioner will have to establish that the teachers concerned, without showing interest, Miller.
No, that is a different thing.
Different.
That is a different thing. But then, in terms of 26.5,
Miller.
why are you not interested to let the petitioner appear?
Miller, say obviously, Miller, he will have 3 chances, Miller.
Have you received your instructions?
Miller.
Then
I
you
will
file
further
an
research.
affidavit, let the petitioner know.
Miller.
Then we can consider the matter.
Miller. That will be better, Miller.
And after all, Mala, here it is the academic interest of the student. All this nitty-gritty of technicalities, in my humble submission, should not be it's not an adversary litigation. That is the very outset I said mine.
In a sense, Miller, the
Do you want notice to go, or then we finish it in the motion stage?
Yes, Lordship. A short date may kindly be fixed, my lord. Let them come up with an affidavit. Because
Okay,
what I understood, that is a small instruction.
PJ Ghosh, Learning Council. Mr. PJ Fukan, Learning Standing Council, Guwahati University. Companies that he has received instructions. And price for?
Miller, at least 10 days time, Miller.
Price for 2 weeks time to file affidavit. Praise the Lord. It will have to come after puja only.
Then it will come after puja. As motion item, Miller.
As motion item.
List on puja is. Okay, 25th of October.
As a motion item.
It will come up.
Publish.
Copy may be furnished to me.
A copy will furnish.
Most of it.
Then.
Eta delay hobe. Maybe
Getting application.
eta delay.
Lord, before my friend start, I take a look at the interim order of the IA, Malad.
Huh?
Malad, they are IA, Malad. Page 99 may kindly be seen, Malad. What the proper adjudication of this matter, Malad? Right?
1 minute.
So record is required, one. Malad,
In the IA page
99.
That is the interim order.
Interim order,
for
Malad,
which
against who is this?
This IA is, my lord.
para 6 and 7, my lord. In view of the above, the order dated such and such as well as provincialization of such and such, assistant teacher of such and such is state until further orders. The respondents, while I am emphasizing this, shall produce the records regarding the provincialization of the school so as to enable the court to examine as to against which subject therefore said two teachers are provincial. So for the proper adjudication of this matter, my lord, this record is required because it is a second sets of litigation.
And it is a second set of litigations, my lord. In the earlier round of litigations, this honorable court initially state provincialization of my service. And on that case, you also in the first round of litigations, I again approached before this honorable court with an interlocutory applications vacating of that interim order. And that interim order was vacated in the earlier round of litigations, and thereafter the matter was heard finally, wherein this honorable court take a view that the petitioner's hearing, my lord, failed to prove himself a teacher who taught
No, no,
classes
no,
of social science.
Let the record.
There's a specific, specific paragraph in this regard, my lord. So for the
I have been
earlier
asked to
round of
file a-
litigations, my lord, the order by which my earlier stay for provincialization has been vacated was not annexed or make any whisper about it in the petitions. If it is made, maybe there will not be any stay order against, at least against me, my lord.
You are the
I am
Respondent number.
respondent number 6.
allow you deal.
Yes, my lord.
My lord, while the disposing of the writ petition, my lord, this honorable court asked this present petitioner to file appeal. Accordingly, appeal was filed. Order was passed. That order was put under challenge in the present writ petition proceeding, my lord. That is why this honorable court asked the department to produce the record against which court this respondent number 7 happened. Altogether, my lord, all the three language teachers were appointed.
In such
In
circumstances,
his IA, my lord, 134 page, my lord, in his IA. This honorable court observed, my lord, IA, page 134.
I,
Right.
well,
134 page, paragraph 6. Mr. N.J. Khatuniya, Learned Counsel for the Elementary Education Department, submit that as per instruction, he has received the respondent number 5, 7, that is the present applicant, 8, whose services have been provisionalized as language teacher. That is why this honorable court asked,
and
my lord.
will also kindly have a look
Produce-
paragraph 8, my lord, of the same page.
No, no, these are all submission, man.
From peripheral of
instruction
notary
say, my
association
lord,
submissions, my lord.
The instruction
It
says,
is not a submissions, my lord.
so therefore the
It's a
record is
observation.
required, my lord.
My lord, may call for the record. I have no objections because it will finish. What a short date may be given, my lord.
Okay, heard, Mr.
M.I. Hussain,
M.A.I. Hussain, Learned Counsel for the applicant.
my lord.
Notice has gone here.
Notice has been served, my lord,
Service is complete, my
and
lord. Other-
all are appeared, my lord.
But no, notice has not been issued.
In IA, my lord.
Hmm.
In IA, pleading has been completed, my lord.
No, that's not it. My lord, that's not appeared in the IA, yes. Well, I filed a reply, my lord, but
1 minute.
But in the writ petitions, all are, my lord,
Is it
represented.
in the
My lord.
IA? IA, you have 40 respond opposite party.
opposite party number, my lord.
Opposite
One.
party number 1 writ petitioner, my lord.
Okay, how about 7 and 8 opposite party?
7, in 8, my lord, in writ petitions, one petition, in writ petition, she appeared, my lord. I will sub copy to the council.
7 not appeared, 8 also not
In
appeared.
8. In 8 in writ petitions, my lord, for 8 appeared, my lord, 8 is represented. I will serve the copy of the IA, my lord, to the council.
Instead of consideration IA, entire writ petition can be also disposed of, my lord.
It can be done, my lord. Enter writ
The rate-
petition.
if
If the report will come
Okay,
and
then I give the head ME as well, then the counsel for the applicant. As well as Mr.
AKS.
A.K. Hussain, Learned Counsel for the opposite party number 1 oblique writ petition. Who appears for the elementary? Who's supposed to produce the records?
No, no, eliminate director is DO.
Respondents বলিয়ে কৈছে। Respondents.
Because written as a respondents, the lordship may give respondents. A upon lordship, I will say
Standing council,
eliminate education.
elementary education shall produce the reports by the next date fix. When do you want?
After vacation.
There is an
Immediately after vacation.
on the opening day, my lord, then.
Opening day.
This was
List on 25th.
25th of October, my lord.
12 and 13 admission.
October.
May I please, Lordship. My lord, the present two petitioners, that is in item number 12 and 13, my lord. In the year 1994, these two persons were appointed. My Lordship may kindly see the appointment letter, page 15 of item 12.
Affidavit has come?
Affidavit, they did not.
Here also lordship, A upon he is on legislative court note 5 lordships. If affidavit not filed, I will inform lordship. Let's me kindly fix it after a week, lordship.
My lord, may be taken at 2 p.m. 1994, we have received only 3 months salary, my lord. Though there were so many.
One affidavit is there by respondent number 3. Isn't it? There's an affidavit. Filed by respondent number 3.
Earlier, when it was dismissed for default, that's why after it was restored. So, well, it was, actually everything is there in the director's order. Everything is there in the director's order. Kindly see director's order, page 16. After long time, so many inquiries were there, and the director was passed this, has passed this order. In exercise of power conferred upon the Director of Film Education Assam by the government, letter number so-and-so, that is so-and-so, and in pursuance of the government order memo number so-and-so, that is so-and-so issued on the decision of cabinet meeting held on 24/2/2005 for regulation of services of 2276 numbers of LP, ME, etc. teachers of state who were appointed in excess of post during the period 1/3/99 to 30/11/99 and which were required into by one-man inquiry committee headed by Sri S. Manoharan IAS and subsequently by task force, district level scrutiny committee, departmental scrutiny committee, the services of 125 ME, MV, working teachers of Bongaigaon district are hereby regularized with effect from the date of their joining against the vacant post as per the encouraged list received from the government in the scale of pay and so-and-so, plus other allowances as admissible as per rules. Now, Lordship, kindly see, this order was passed after so many inquiries. And my name appears in serial number 118. That Lordship may kindly see page 20. 2118 Solimuddin. So this Solimuddin has got only 3 months salary. This order was passed by director on 30/1/2006. Thereafter, I was attached in a school. That school did not allow me to join. Then I was attached in the DO, Bongaigaon. In that manner, I was working. Then I was given the substantial post in Tilbukuri LP school. There I am working till today. But till today, no salary has been paid.
No salary till today.
And in other case, Hafizuddin, he started receiving salaries. Both the persons are on the same
In this
same order.
Yes.
In item 13, which is Hafizul,
My lord, I have received my instructions, my lord. I need to bring that on affidavit. And my lord, in Solimuddin case, that is item 12, that we have already, I think, filed, the director has filed an affidavit. My lord, since they are analogous matters, my lord will give me some time so that I can bring the, this thing. As far as the, Hafizur case is concerned, my lord, the second case. There, my lord, I have received instructions orally. I'll just read it out, my lord, that he's been, would I state that, the petitioner Hafizur Rahman has been accommodated as tutor by so and so, dated so and so. Accordingly, this office had issued appointment letter as tutor to the petitioner on so and so in Bonganga district, and accordingly they joined in the respective schools and have been receiving wages since his joining till date, and as reported by the BEO Sri Jangram. So, my lord, there's
Yes,
a
my lord.
three these things. So
Hafizur
I will be allowed to
Rahman,
bring it on record, my lord.
my learned friend is to some extent correct. Hafizur Rahman is receiving salary since November 2021.
Since, my lord, they have accept, there is a thing, there's a catch to it, my lord. Since they accepted the tutorage, my lord, they have to forego the previous thing, my lord. That was the thing, my lord. But I will get allowed to get instructions on that also.
I have also forgone.
So let me get the
Mr.
instructions, my lord.
M.E. Mahmood, learned counsel for the petition. The respondent number 3. Has filed affidavit in WBC number 7058 of 2015. Stop, Mr. A. Fukan, and the Standing Council Elementary Education Department supports that he has received
Instructions for 6786
instructions
for the 6786
in WBC 6786 of 2017. And praise for how much time?
2 weeks. Immediately after the vacation, my lord, may
Praise for
please.
2 weeks time.
On the day,
Well,
that's why we disposed of my lord, because
praise the Lord.
what's suffer?
This on 28 October.
28.
October.
15.
May it please your lordship. Your lordship, on last occasion, honorable court has asked them to bring instructions.
Yes.
My lord, that DLC, my lord, which private responder has been, my lord, recommended, that is in 2011, my lord. And now he is challenging his appointment.
In 2019.
My lord, 2019. Even, my lord, is a compassionate appointment, my lord. Mainly,
3 grounds you have taken earlier, that the private respondent was appointed in the year 2011, and the writ petitioner is challenging the 2011 in the year 2019. One ground. The other ground is that the father of the petitioner died on 2/1/2007, and he made his application on
31st August 2007.
My lord.
31st August, correct?
My lord.
And as per your reports,
My lord.
the application of the petitioner was on 17/4/2017.
My lord.
Notices complete on the private respondent?
Yes, my lord.
Who's appearing? You are appearing? Okay. You have your instructions? You have your instructions. Last occasion time was given for you to receive instructions.
It was on 26 June last, my lord.
Section regarding the my lord, financial comparison, my lord, that have to be that from the concerned administrative department. Here, my lord.
Here
petitioner-
says on request made by Mr. B. Deurel and government advocate, list the matter immediately after summer vacation to enable him to receive instructions. So what instructions have you got today?
I don't know inspection. My lord.
My lord, it's already been more than 5 years, my lord.
$5 years, you have no instructions.
My lord. No inspection in the record, my lord. No inspection in the record, my lord.
I'll give you 1 week time. You get your instructions.
That instruction regarding, my lord, that
Regarding the writ petition, that the petitioner, what the petitioners filed.
apart from, my lord.
Have you at least gone through the pleadings?
My lord.
What does it say?
2011, my lord, recommendation given to the private respondent.
Correct.
Now he is challenged in 2019
Hmm.
by saying that his appointment was wrong, my lord. His father was working as an assistant inspector in the school. Therefore, his financial status is, my lord, high to him. That is his claim in this petition, my lord.
But my lord, cause of action arose after the rejection by the DLC. That's why I have
And
appealed
my
before
lord,
the honorable court.
When did the DLC rejected your case?
In 2017, my lord.
2017. Still in after that again 2 years. Okay, you take a week's time, I'll fix a date, and that day we'll dispose this matter.
my lord.
But within this week, my lord,
Heard Mr.
NC Kathazorika.
NCK Hazarikal and Council for Technician. On request made by Mr. B. Cycle and government. List the matter after 1 week. To enable him to receive. MS K. Morali, Leonard Council. Appears for the response number 5. Okay.
Much older.
May please your lordship, Mr. B. Chaudhary appears for this matter, my lord. As on today, he is on bereavement, my lord.
Lordship, kindly period the last order, lordship.
My lord, he is on bereavement, my lord.
Okay, he's in bereavement, so. Heard Mr.
AK Das, lordship, on behalf of M. Khan, lordship.
AK Das, Leonard Council, appearing on behalf of Mr. M. Khan, Leonard Council for the petition. It is submitted that Mr. B. Chowdhury, Leonard Standing Council,
BTC, my lord.
BTC is in bereavement. And place for adjournment of the matter.
Date will be given, lordship.
Praise the Lord. This after puja.
Date will be. Obliged, my lord.
18.
May I please, Your lordship. Lordship, in this matter, I may be allowed to take an instruction from my petitioner, lordship, because almost 4 years has been gone. We did not contact with him. One week may be given, whether he is present at us, whether he is alive or not, lordship. I do not have any information regarding him.
Okay, Mr.
U. Sharma.
U. Sharma, Leonard Council for the petitioner. Place for a week's time.
Yes.
To enable him to receive instructions as to whether the course of action still survives.
Yes.
Praise the Lord. List after 1 week.
Obliged.
19.
May I please, Your lord? Lordship,
Instruction is awaited.
Lordship, this is regarding correction of dice, my lord. The last date of correction of dice is 30
Oh,
September.
the Bora was just here.
Yes, he's on this.
As per Lordship, Annexure 5, my lord, this matter may be disposed of, my lord.
I heard council. You're not appearing.
I'm, means he told instruction is awaited, so let the matter come next week.
Then we'll fix a date.
This is at least annexure 5, my lord. There is a direction for correction of dice, my lord. I want only current year. Annexure 5, page 59, my lord. This letter is issued by Executive Director SSA, my lord, to the District Limited Division Officer. As per this order, my lord, this matter may be disposed of.
Annexure 5 letter.
Yes, sir.
Here it says dice cannot be corrected.
If from current year, my lord.
Huh.
It is it can be corrected in dice from current year, my lord. Last portion, my lord, in this letter, my lord. I want only correction from current year, my lord.
Anyway, we wait for some time then.
Let it be taken after some time.
We'll take up after some time.
Most.
20.
May I please, your lordship? It is honor before your lordship is his salary has been stopped from 2018, June 2018, my lord. And thereafter, even after the interim order passed by this court to pay the salary, I have filed an additional affidavit on 2/4/2024 where I have annexed that order. And even then,
Which additional affidavit?
2/4/2024, I have filed an additional affidavit, my lord, on wherein an interim order passed by this honorable court, my lord, where it was stated, my lord, that page 100, my lord. Page 100. I am reading from paragraph 8. In the aforesaid circumstances, we do not find any prima facie reason as to why the petitioner has not been paid the salary and allowances. Accordingly, in the interim, it is directed the respondent to pay the salary and allowances to the petitioner. It will remain open to the respondent to take note as to which school the petitioner will serve in either of the two schools. If Uttar Panpara and P School Jala create an obstacle to the petitioner in this discharging duty, the respondent to the district elementary education officer shall take appropriate measure, including provide security to the petitioner for the purpose of discharging duty. That order was passed on 24/9/2021. After that, the respondent authority is seeking silence, my lord, and nothing has been done.
May I please, your lordship? I'm appearing on behalf of respondent number 10.
Respondent 10.
Yes, ma'am. Yes, sir.
Yes.
Sir, I have joined on July 2, 2018, and I have retired from the Dakhin Kalihapar LP School on 31/12/2021. Till retire, I was drawing my regular salary and also I was getting pension. And this court, and the petitioner has filed a complaint, my lord, that I did not apply for mutual transfer. But yeah, your lordship, a complaint has been made and an inquiry has been done.
No, what do you want today? You want to file your affidavit or?
No, no, your lordship, I want to give submit a copy of the order which has been given by the government of Assam or Office of the Director of Elementary Education.
Lastly, what happened, that inquiry was conducted by the inquiry committee and the matter was resolved by it, which was I have annexed, where in
But lordship,
annexer
nothing was found against me.
Annexer 23, page 84 of my writ petition, whereby it was established that the respondent number 10 has fraudulently
page
84 of my writ petition, Annexer 23, my lord.
You have a typed copy of this. It's not readable at all.
I am reading, my lord. Small paragraph. In compliance of the government order number dated 4/2/2021 and the pending royal of departmental procedures, Srimati Rohima Khatun, assistant teacher of Uttar Panpara LP school under BEO Jala in Borpeta district, joined in 1125 of Dokhin Kaljar LP school in place of Montus Medak, assistant teacher under BEO Bhavanipur is hereby placed under suspension with immediate effect as she fraudulently make the make an application for mutual transfer. And thereby he was allowed and thereby she was placed under suspension, my lord.
You have a better copy.
I don't have, but this is same copy. I
You
think.
finish your type copy.
Yes, my lord. And that issue is already been resolved by the conducted by a departmental inquiry, and that order was a departmental inquiry. And while does this honorable court pass an interim order, my lord, that was very much clear in paragraph 7.
Yes.
That the in the order in the interim order, it was also stated
1
in
minute.
page 100, my lord, in my additional affidavit, which was filed on 2/4/2024, where it was also stated in this order highlighted that a hearing was provided pursuant to the order dated 6/12/2019, page 100, my lord, page 100 of my additional affidavit, which was filed by the petitioner on 2/4/2024, and paragraph 7. Paragraph 7, a hearing was provided pursuant to the order dated 6/12/2019, which resulted in the inquiry, and the inquiry stated that it was revealed that the respondent number 10 had committed certain fraud, and as a result thereof, it is also stated that the respondent number 10, Srimati Rohima Khatun, is placed under suspension. So that issue already been solved, my lord, and he was suspended, and the petitioner joined where he was transferred, and that was transferred, and he joined accordingly, and SMC of the new school where he has joined has accepted his joining letter. But while that is also in my affidavit, the BEO issued the letter to the Director of Elementary Education on 24/5/2023, that is 102 page, my lord, in my additional affidavit. After interim order, the respondent authority is sleeping for 2 years. Nothing has been done. On 2023, when the petitioner time and again visited the office of the respondent, district elementary education officer, to release his salary, that they were saying that his service books and last certificate, the file of the petitioner was missing from the office, my lord. And that was also stated by the BEO in the Jala block to the Director of Elementary
Who
Education.
appears elementary?
Petitioner is suffering a high diabetic and
So you are still not receiving your salary?
not a single month. From June 18, my lord, till date. Even after a clear direction from this court on 24/9/2021, and nothing has been done till date. Petitioner is suffering, kidney alignment and he has no money to take medical care. At least my lord, current salary may be released.
Your lordship, if you may allow, according to the order which I have given, an inquiry has been made and nothing has been found against my the respondent number 10. If you may kindly read, please look at the order where it says, whereas Srimati Rohina Khatun retired, so and so. Yes, yes.
It was already suspended through an inquiry. my
No, no, our suspension revoked, reinstated back.
Yes, yes.
Disciplinary proceeding dropped.
And he was also
Suspension,
retired also.
suspension period treated as in service. So there's nothing against respondent 10.
Yes, yes, lordship. That
The only issue is that
mentioned.
now that you've gone and joined your place of posting,
Yes.
you're
I have
supposed,
joined, my lord.
Kaushik, this is one issue. Where there was an allegation of fraud, submission of mutual transfer. The respondent 10 in the petitioner. The respondent was placed under suspension. And after that, he was reinstated. She retired. Disciplinary proceeding closed after the proceedings, and the suspension period was treated as on duty for all purpose. That is so far as respondent 10 is concerned. The petitioner, in view of that mutual transfer, proceeded to his place of posting. And from June 2018,
Yes, my lord.
he's not getting his salary.
I'll get the instruction.
This is not fair.
At least my lord, current salary may be allowed, release my lord, because petitioner.
And
There is an order passed by this
1 week time, my lord.
interim order passed on 2021. They are sitting from 2021 to 2024 May. 4 years they were sitting, my lord. Nothing has been done. And nothing has been done. Actually, this is supposed to be a contempt case, my lord, for non-compliance of the order.
There's already an order passed by this court
Yes.
directing to pay the to pay the salary and allowances.
And my additional affidavit, the lordship kindly peruse the 102 page number and extra 3 of my affidavit, where the BEO elementary education officer accepted that he has joined in the newly transferred
Yes, yes.
school. After joining the school, on last occasion, my lord, 2-3 times they have took time to instruction. Hereby the petitioner is suffering, then he is a kidney alignment patient, my lord.
But MSA budget well and counsel for the petition. Mr. B. Kaushik, London Standing Council Elementary Education Department, place for weeks time to enable him to receive instruction. List on 23rd Monday.
Monday.
That day
I'll get the instruction.
21.
Kindly pass off for the timing. The DK Roy is on lake on foot number 10.
Lordship, issue is very limited, my lord. In this case, my lord, regarding correction of date of birth. And I relied upon, my lord, the admission register book maintained by respondent 5. Respondent 5, my lord, probably present, causally shown and my lord, office to dated 29/3/2022. The respondent number 5 enter appearance by filing Okalot, my lord. Let them file affidavit if my date of birth.
Who appears for respondent number 5?
Respondent 5 necessary. Other is not necessary. If respondent 5 is stated that my date of birth is correct, then my lord, it's very easy.
Respondent number 5 from Chairman.
No, respondent private respondent, headmaster.
Who entered appearance? Respondent.
Some hawk. Respondent 5.
Yeah, Roy.
My lord, we have the instruction, my lord, we need to file affidavit.
Okay, heard, Mr.
K. Bhuyalosh.
K. Bhuyan, Learning Council. Mr. DK Roy, Learning Standing Council, Seba.
Seba.
Place for how much time?
My lord, 2 weeks, my lord.
You headmaster.
2 weeks.
No, my lord, not for headmaster, for respondent 1, 2.
I say Seba.
Yes.
Place for 2 weeks time to file contract.
And respondent 5, my lord,
List after 2 weeks.
respondent number 5, my lord, is them shown in the positizing. And so far, my lord, ordered office note 29/3/2022.
Right.
Lordship.
23.
May I please, your lordship? Your lordship, on 19/8/2024, your lordship, instruction was directed to the state respondents as well as to the respondent number 4 and 5.
Yes, as
In this regard, I have received one instruction here, my lord. May I read, my lord? Here, my lord. And last three paragraph. In this context, it is to be stated that as per government notification so and so dated 10/6/2010, the school management committee is the sole authority to appoint a teacher on contextual basis, and the school management committee is entitled to terminate the agreement and made with such teachers at any point of time at their discretion without assigning a reason for such termination. However, right government notification number so and so dated 28 February 2018, these contextual teachers are entitled to grant of leave without pay, but on being recommended by the concerned inspector of schools slash head of the institution. Now, in the case of petitioner, it is seen that though her leave application was forwarded by the inspector of schools and this in Nagaon, but there was no recommendation from the concerned authorities as per rules prevailing at that time of at that
so
time.
it is the inspector of schools.
Yes, either inspector of schools or headmaster.
So have you taken instructions, at least from the inspector of schools?
This is coming from director.
Yes.
Your lordship, may I submit? Your lordship, in this matter,
And in the last line, her leave should have been recommended either by the concerned.
That's why I'm asking you.
Yes.
it has been recommended by the headmaster, your lordship. I have annexed to my petition, your lordship, Annexure G, your lordship. Forward, page number 37, your lordship. 9/8/2018, it has been forwarded by the headmaster to the inspector of schools, to the director of secondary education, your lordship. Page 37. And your lordship, Annexure H also, if your lordship peruses, page 38. It has also been forwarded by the inspector of schools, your lordship.
Yes, that's the reason why in the last occasion on 19/8/2024, this court asked you a question whether the director has granted the leave.
Yes, your lordship.
The headmaster recommended inspector placed before the director.
Proposal has been forwarded to the director, my lord.
That's why I'm asking you whether the director.
Recommendation has not been met. A proposal has been provided.
I don't know whether recommendation was made. I just want to know whether the director granted the leave.
No, my lord. Here it is.
There's nothing on record to show that the director did not grant leave. I want that answer.
But my lord, from this instruction, it is clear that, that the recommendation authority is either inspector or headmaster. Her leave application was forwarded by the inspector of school and this is Nagaon, but there was no recommendation.
So this court asked you one question. Have you seen the order passed by this court on 19/8/2024?
Then I have to take instruction.
Whether the director granted leave?
Yes. I'll take.
If the director did not grant leave, say the director did not grant leave.
Yes.
If the director granted leave, you say the director granted the leave. That's all.
Yes.
This court does not want to know whether it was recommended or whether it was not recommended.
Your lordship, may I just submit, your lordship?
Yes.
Your lordship, the proposal, sending of the proposal by the headmaster in my humble submission as well, your lordship. And to the inspector of schools who had also forwarded the same proposal, that it shall amount to recommendation, your lordship.
That will see.
And furthermore, your lordship, the childcare leave note order, your lordship, it has been made clear on the recommendation, the director is incumbent, your lordship, to approve or the grant the leave.
Heard Mr. D.S. Dika.
Yes, your
Learned
lordship.
Counsel for the petition. Mr. U. Sharma, Learned Standing Counsel. Secondary Judicial Department. 1 minute. Praise for how much time? 1 week?
In this manner,
That will come after the puja.
before puja, my lord.
Press for weeks time to enable him to receive instructions. Based on third of October. MS AOCN Learned Counsel appears for the respondent. 5. Have you got the school attendance register?
Lordship, the entire documents, the headmaster have himself submitted to the state. The original documents, so I could not submit it before your lordship today, because the entire documents has already been submitted.
Then you will have to produce.
Lordship in the earlier order said for the month of September, but you have submitted for the whole year.
Okay.
Much obliged, your lordship.
19.
Yeah, my lord, I have not received my instruction. My lord, will post it in next Monday. My lord, get the instruction. So only the current dice code had to be made, my lord. Otherwise, he will not get it because they all PI has late.
No, that's what he wants. He wants the current.
Finally, only the possible next Monday, my lordship fix. I will get the instruction.
Okay, Hurt MS.
D. Datta, lordship.
D.
Datta.
Datta Learned Counsel for the petitioner. On request made by S. Bora, Learned Standing Counsel, SSA. This the matter again on 24th.
Not sure.
24.
Lord, I am appearing for the respondent number 5, your lordship. Lord, kindly some time may be granted for filing affidavit, your lord.
My lord, this is a matter of 2023, my lord. They have entered appearance my lord, long time ago. And my lord, they are seeking time because their services has been provincialized and the petitioner's service has been left out. So lordship may give them
About
last chance.
elementary. Have you filed your affidavit?
No, no. If Fukon, he is supposed to appear lordship. Lordship may kindly grant some time, 1 week time.
See, granting 1 week is easy. The thing is, are you filing that affidavit within that 1 week time?
This action was allowed to pay Fukon lordships, on his behalf, lordship may kindly grant 2 weeks time, lord.
Yes, Raman, how much time you want?
Lord, within 10 days, I will file, my lord. Within 10 days.
Okay, Hurt ISIQL and counsel for the petitioner. Mr. A. Fukan, the standing counsel, Elementary Education Department, as well as Mr. R.
A. Rahman.
A. Raman, learned counsel for the respondent number 5. Are both allowed 2 weeks time to file the respective counter affidavits. List up to 2 weeks.
Also fix the date before vacation, my lord. Before vacation, also fix the date, my lord.
It will come after vacation already.
Also fix the date, my lord. After vacation, also fix the date, my lord.
After vacation, fixing date will be big, there'll be a big issue. You make your mention.
Bless. Bless.
25.
May I please your lordship? Lordship, this matter pertains to non-payment of arrear salary from 16/10/2015 to 14/7/2022. On last occasion, the respondent authority was supposed to file a counter affidavit. But
My lord, Mr. B. Chaudhary appears for this matter, my lord. One previous man, my lord. May I prefer listing this matter immediately after the petition, my lord?
Yes, your lordship.
Third MS,
A. Sharma on behalf of A. Bujor Burwa.
A. Sharma, learned counsel appearing on behalf of Ms. A. Bujurwala, learned counsel. On request made on behalf of Mr. B. Chowdhury, learned standing counsel BTC, list after the puja vacation. To enable him to file contract.
Not obliged. Lordship, item number 26 is also same.
Same
The mat-
submission, my lord,
same
with regards to item number 26.
Same order.
Not obliged.
Highly obliged, my lord.
27.
Not with this item 27, my name should not have been reflected in against in the respondent column. It should have been standing counsel elementary lordship. That's why our clerk has missed this item lordship, and the higher and elementary both are parties. This is regarding lordship's share of the pension by the respondent.
The mother has claiming share is 77 years mother bedridden. Is not provided. And earlier also approached this court, your lordship has a pass order in page 32. Gratuity alleviation was granted.
Private respondent one party.
Respondent 7.
Respondent 7 should be directed to personal appearance, appear personally lordship before the honorable court.
She also a government servant, but she is not, after justice service also, she is not
She
appearing.
is not appearing, she is not responding to the court's notice of this honorable court.
Therefore,
Department cannot do lordship. She should have been appear personally lordship.
she is the headmistress of an school. Therefore, school has directed the elementary to make party to ensure her appearance before the school. In fact,
Making elementary education will not help lordship. She should have been give a direction for.
Who's the respond number 7?
she is the daughter,
She is the daughter-in-law of the
petitioner,
petitioner.
yes. She is also
Daughter-in-law of the petitioner, and she is not sharing that pension with her mother-in-law. That is the dispute. That is the dispute lordship.
next in.
There is a provision in the rules, isn't it? If the is not shared and the complaint is made,
Yes.
then you have the authority to take steps.
It's a pension department, not the parent
That's
department. Yes.
So who applies for the pension department?
Pension government or no.
No, that department can also do on higher education is.
Where is that provision in the pension rules?
There is also notification also I have annexed.
That provision in the pension rules? 100.
His mother's name is there, is amended to replace. In this book is 159. Page 158. Mother. In this book, page 58, this mother's name is there. Mother's, like.
No rule, which rule?
Yes, sir, service pension rules 1969 amended rule. As per the mother is entitled. But there is a notification, government notification, if it's not complaint, is I have annexed that to your lordship, the notification, page 43. Page 43, relevant for your lordship, page 44, 510, bottom yellow.
This is for compassionate family pension lordship, not for the regular family pension.
It is the father, the son of the died in harness. That's what it is covered with that notification. Page 44, your lordship.
You're getting the pension in terms of this notification?
Lordship.
Are you sure?
Lordship, I'm happy to get. Page 44.
তুমি এইখনৰ মতে পেঞ্চন পাই আছা নে বেলেগ নামটো কোৱা নেকি কি পাই আছা কোনখনৰ মতে পাই আছে
এটা গম নাপাওঁ তাৰমানে এইটো দিয়া নাই না
the pension lordship for
Government has
pension has been received by the respondent 7 not by the petitioner.
I'm
Her
saying
share
here,
she is not getting, that is why she has come before the court.
77 years old mother and
And
she is
respondent 7 is not responding to the notice of this honorable court.
Did you make a complaint?
Yes, sir, I complained.
Where's the complaint?
Says your lordship 40, 40.
40.
Before the Secretary Higher Education Department, the son is a associate professor of a college. Page 40, your lordship.
Then, Chishti, you'll have to take steps in terms of the complaint.
It is about higher education. Did who department involved, lordship? Her husband was working in higher education department. Now the response 7 is appointed in an elementary, under elementary education.
Yes, sir.
So it will be better, lordship, if a lordship give a direction to the response 7 to personal appearing, because justice service was served upon her. In spite of that, she is not appearing. Only she could explain why she is not giving that share to her mother-in-law.
Second person is
It's a dispute between the two
Yeah,
persons.
And page 28 was earlier also I'll file a complaint.
It is better she could come and explain to the honorable court why she is not sharing her that pension. with
Another
her mother-in-law.
complaint, your lordship, page 28.
It is not that she did not receive anything. She has received the justice notice, lordship. In spite of that, she is not appealing.
The action honorable court by order dated, your lordship, implement 17/5/24, order dated. Implement the education 17/5 order, your lordship. 17/5/24.
In item 2.
Okay, Hurt is Islam.
Lordship, may I leave? I have an item in court number 10. Just leave for a second.
Learned counsel for the petition.
May I leave it too?
Also heard Mr. SMD Chishti.
Yes.
Learned standing counsel.
It was
Elementary,
elementary.
Elementary Education Department. Who appears for the higher education?
I am appearing for one.
Mr. D. Upamanya, Learned Council, Standing Council, Higher Education. Stop. Para. And the MS, A. Sharma, Leonard. You're the standing council.
On behalf of beach.
Leonard Council appears on behalf of B. Chakrabarti, Leonard Standing Council, Accounting General. Stop. Para. The claim of the petitioner in the present petition is that after the expiry of her son on 26/10/2018, the respondent number 7, who is her sister-in-law, who is her daughter-in-law, started to receive the compassionate family pension. Stop. However, the respondent number 7 is not giving her share to the petition. Is not giving the share of the petitioner. No, don't say compassionate family pension, huh? The set pension. No, however, the petitioner has not been given any share of the family pension by her daughter-in-law, oblique respondent number 7. Where's the dusty service notice?
I have filed affidavit, your lordship.
Where's your affidavit?
I filed on 7, 17/7/2023. 17 July 23, your lordship. Filed affidavit.
But the respondent number 7 was the notice on the respondent number 7 was made by Dusty Service, to which the petitioner has filed an affidavit to that effect. For which, not to, for which, start. However, till date, the respondent number 7 is not making any appearance before this court. Accordingly, the respondent number 7 is directed to appear in person before this court on, where is this place?
It is under, she's an headmistress of Borpeta, Your Lordship.
You have not written headmistress, nothing.
Lordship. But I am the body I have written. Body I have written.
Will the notice go?
Notice address, Your Lordship. But it is ensured by the Department of Elementary Education.
This procedure should have been very clear. This procedure should have been clear. He has made an allegation against Respondent 7 and it is not written what.
That's the whole problem.
It should have been very clear. This is working as so and so.
No, no,
That's procedure itself.
Page 6 I have stated she is a headmistress.
The statement is.
The address.
Address I have, residential address I have given.
How can can we know that the respondent number 7 has received the order passed by this court for personal appearance?
The department issued, she is a government servant, department can ensure.
Why department will ensure all the time? It is that this private dispute lawsuit, they are not getting pension and department, they all the time.
You correct the address of respondent number 7. Cancel the whole order. Cancel the whole order. Mr. S. Islam and counsel for the petitioner is allowed a week's time to file an appropriate application for correcting, for correcting the address of the respondent numbers.
Amended procedural end.
Released after 1 week. You file an application, after that we'll pass orders.
28.
May I please, Lordship? In this case, my lord, we have challenged the impugn order passed by the finance department, my lord.
Lordship, here my learned friend, he is challenging the impute order and he is aggrieved by the fixation of pay scale of the sub Lordship. We need to file an affidavit. Inadvertently, we have missed out on this matter, Lordship. I'll pray for any date after the vacation, Lordship, so that we can file an affidavit, Lordship.
In the affidavit, my lord, your lordship will indicate that they have to answer, give the clarification whether the salary of 2 persons appointed on 2 different dates will be equal.
Your writ petition is before them.
They
know what to answer.
This is second round of litigation.
Yes, Lordship. We have already passed the, it has been
Last
rejected.
occasion, my lord, they have filed the affidavit in the earlier, we have annexed it in the writ petition.
Mr. B. Procastle and counsel for the petition. Mr. H. Alial and standing counsel finance department is allowed 2 weeks time to file evidence affidavit. Please after the puja petition.
29.
Same.
29 days, the private respondent inspector receiving this, he has not appeared. Now he is getting interim order lawsuit stay. Let it come after 4 weeks lawsuit. We have also yet to receive the instruction. And last
They filed the affidavit, my lord. Yes, they filed the affidavit admitting that I am the senior, my lord. Senior most. Oh, last occasion was given direction to dispose of, my lord, this.
Your director has filed your affidavit.
Affidavit filed, my lord.
Who is the private respondent?
Private respondent is the, my lord, is the teacher of the school, my lord. He has got the notice 3 times. We have sent already notice received and the Lodgem order is there. Service is complete and the order is also there, my lord. And he is not interested to come because he has no B.Ed degree. How he will come? He cannot claim also.
only thing is justice service should have been given a chance to be given to the respondent.
No, this court has already accepted.
Already accepted, my lord.
Notice.
Page 18 is the in the read petition, my lord, is the or seniority list. He has no B.Ed degree, admitted. And I am the only B.Ed holder. Senior most. Impugn order at page 23.
Okay, that's an error. Now, Lordship, the director has already allowed the petitioner to hold the cert.
Listen,
এখন কি error?
এটা দিও
334
না না আরে আমার তো ইনফরমেশন দেন
ACM temporary allowed to apply for any.
না দিছেন
44 টা কিসে? না 44 টা কিসে?
44 টা এটা দিও না কোটা এটা দিলে তো হয়ে যাবে ক্লোজ করে
কি এফিডেভিট লিখে মই গভর্নমেন্ট পেজে নিয়ে আমি কি লিখতে পারি?
এগুলো দিয়া না তো
হ্যাঁ
তো দিয়া না
এই জন্য জানা একটা কি লিখেছে তাই
Yes, Chief Chief.
affidavit, Lordship. Affidavit, what I have seen, Lordship, filed by my colleague. In para 7, it is here that petitioner has been temporarily allowed to act as a headmaster inserts. Para 7, Lordship, my colleague see the affidavit filed by director. So in that case, Lordship, that he has got a relief.
order to দিও
But order copy has not been annexed, Lordship.
Where is the order?
I have, this is an,
এটা নিবি
no, sir, I have to verify, but it was filed by my colleague, Lordship. I have to verify before submitting, Lordship. Because
You've been allowed to hold.
Yes.
I will take also instruction, my lord.
He does,
You take
he should-
instruction.
he should have get the instruction.
Okay, Mr. AK, B. Broadcaster and counsel for the petitioner is allowed how much time?
It will come on Monday, my lord. By this time.
It's allowed a
Only tell him.
week's time to enable him to receive instructions. List down. 24.
30.
In this case, my lord, they have not filed any affidavit yet. Actually, with regard to the promotion to the post of headmaster in the upper primary schools, my lord, the issue is involved that we have challenged the notification and they have not yet responded.
We have received instruction. Let us file our affidavit.
Part B. B. Broadcaster and the counsel. Mr. P.K. Bora. Then the standing counsel, elementary education department, submit the as received instructions. And press for 2 weeks time?
Well, after
A date, my lord.
Press allowed. Press after
Puja
the
vacation.
Puja.
Any date after puja, my lord.
Bless.
32.
After Puja, you'll have to make this.
Here, my lord, I have not received instruction.
And in this case, my lord, I have challenged the my lord, the selection and appointment of the Resolution number 7 as the president of a school management committee. My lord. Now, it is an admitted fact that my lord, he has knows my lord what in the school. He my lord became a my lord guardian, self-styled guardian by a declaration made before the my lord sub-registrar. Then my lord, it was my lord submitted before the deputy commissioner. Though on inquiry, his presidency was my lord terminated. Subsequently, he was allowed to continue. So I have challenged that my lord subsequent order of the deputy commissioner. And in this case, my lord, the affidavit of the deputy commissioner is my lord necessary.
Who appears for the deputy commissioner? Okay, heard Mr. D. A. Kayum.
Lordship,
then
I
the
am
counsel
appearing
for the
for
petition.
respondent number 7, Lordship. I have already filed my affidavit.
Yes.
And Lordship, this is pending since April, Lordship. They have not filed any affidavit, deputy commissioner.
Mr. You appearing? P.K. Bora, then standing counsel elementary education and Mr. B. Saikya, then the government advocate for the respondent number.
Resolution number 2, my lord.
Respondent number 2 are both allowed 2 weeks time.
ALM Sheikh Lordship, appearing for respondent number 6 Lordship.
You have filed.
Yes.
Private parties has filed.
Are both allowed 2 weeks time to file the respective affidavits.
My name be recorded.
This
Respondent number 6.
on
M. Ahmed.
on the top, you say also heard Mr.
M. Ahmed.
M. Ahmed, Learned Counsel for respond number 6,
Seven.
7, and Mr.
ALM Sheikh for 6 Lordship.
ALM Sheikh for the respond number 6.
33.
Maybe. In this case, my lord, last occasion, my learned friend has taken time to confirm as to whether I was not given the charge of the principal of the school for not having the NOC. And page number 41 is the reason, my lord. Serial number 4.
Yes.
That on account of not having the NOC, I was not given the
Principal.
yes. Sir. So your lordship may disposed of similar orders are there, my lord.
My lord, in this matter, I have received the instruction here, my lord, and my lord, as per our instruction, he has not completed the 17 years as a graduate teacher, which is criteria, one of the criteria of the selection of principal.
17 years?
Yes, 17 years, 17.
Is it 17 years?
Yes.
17 years, my lord, post has to be created. That post is not created, my lord. Principal is higher secondary school is declared without any post. It's like government declared venture school.
Okay, heard Mr. B. Purcastle and Counsel for the district. Mr. U. Shamal and the Standing Counsel, Secondary Education Department, subject. He has received instructions and prays for 2 weeks time.
2 weeks time.
To file affidavit. Praise Allah. Please after puja.
34.
Wait, is it okay?
Lord, yes. Must be thus.
In fact, your lordship, I had furnished a copy before your lordship dated 26/12/2018, which may be in the file records.
26?
Yes, 26/12/2018. So these are their documents, your lordship. There's nothing else to be adjudicated in the matter. He was selected for that post. Now the writ petition has been disposed of. There is no interim order.
Yeah,
There's nothing that
Kaushik.
stops me from being appointed.
Receive the instruction.
Halaniki?
Yes.
You've got the instruction?
Malik.
Okay.
Which school are you for?
Jajori, your lordship.
Jajuri higher secondary school.
Yes,
The
your
same
lordship.
school, Melon. That post was advertised in 2020.
The intimation of cancellation was never conveyed to me. If that is the line of argument that the state is taking, it was cancelled. In fact, everybody else in that
He is not a party. The person who has been appointed now.
You have for the post of postgraduate teacher English.
English.
Have you given him a copy?
Well, I'll give him a copy. I have just received.
You have to go through this,
Yeah.
give him. I think you'll have to.
Maybe your lordship will grant us liberty afresh if there is a new person to be implemented. But that just gives
Anyway, let him go through.
Okay. But there has been the letter is self-contradictory in the sense that they say that I was selected, and then there have been no appointments because the Honorable Court had opined that the put in a stay. Now, in the pendency of that, my my selection was never cancelled or interfered with by this Honorable Court. It was merely stayed. And now they've issued a fresh advertisement without cancelling the earlier advertisement.
Just check up.
Yes, then maybe your lordship will fix the matter as per your lordship's convenience on a date which is convenient to your lordship. Then maybe we can take the matter forward, or maybe I'll obtain instructions from my client to withdraw and file afresh. That depends on the client. This client also needs to see this.
Possibly the scope of challenge has to be changed.
Yes, the scope of challenge
Yes.
will have to be changed.
On request made by Mr.
M. Sharma.
M. Sharma, that's counsel for the petition. When do you want?
I'll leave it to your lordship.
Take a short time and then
The last couple of weeks, maybe miscellaneous weeks, so your lordship can fix it after the vacations also, or maybe
this after the puja.
if a date can be given, your lordship, I'll be grateful.
No, puja after puja, giving dates.
Yes, I'm grateful, your lordship.
35 to 64.
If your lordship kindly peruses the last order, my lord, the order dated 28/8/2024, SSA had submitted that they wanted to file an affidavit and the affidavit had gone for vetting.
Mr. B. Tutor appears for this matters, my lord. Indeed, it has gone for vetting, my lord. In some of the matters, my lord, affidavit has been filed, my lord.
File?
My lord, sorry, it has gone for vetting, my lord, my mistake.
Let it be after the vacation.
But Mr. A.K. Barwal and the council. Are you the only council or there are
My lord, 35 to my lord, all the matters except for 58, 50, 59 and 60, I think Mr. Majumdar is appearing.
58,
59 and 60, Mr. Majumdar is appearing.
Okay, heard Mr. A.K. Barwal as well as Mr. K.M. Majumdar, learned councils happening on behalf of the petitioners. On request made on behalf of Mr. B. Chowdhury, learned standing council SSA. This is the matter after the puja vacation to enable him to file counter after. Interim orders passed only to
My lord,
till the next meeting.
my lord, may I prefer listing this matter after 10 days, my lord? Stay as no. Stay like that.
71 order. $71.
As per Lodgement Court order, they have to take first step upon respondent on 7.
None appears for the petition. The office note. No. The proceedings of the Lawazima God dated 6/8/2024. Indicates that the petitioner has failed to take steps upon the response number 7 as directed by the Lawazima Court orders on 7/5/2024 and 21/6/2024. Today, when the matter is called up, none appears for the petition. Writ petition is accordingly dismissed for non-prosecution. Obliged.
72.
None appears for the petition. Please stop for 2 weeks.
73, 74.
Lordship, may kindly see page 8, paragraph 11. Page 8, paragraph 11, Lordship. My accumulated mark, Lordship. Cases 52, BA 44, MA 57, DLS 72.8, TATE 58.6, and accumulated mark is 228.51. Lordship, the mandate is that one should have 50% in the graduation. Although, Lordship, I did not have 50% in the graduation, I being an OBC candidate, my marks was 45%. I recall 45%. My BA percentage was 44.64. So, Lordship, by rounding off the decimal figure, it could also have been considered as 45. Lordship, I have given several examples, those several candidates who got marks below in degree examinations, they were considered in respect of MA marks, Lordship. In the master degree, Lordship, I got 57%, but my case was not considered. The other, Lordship, I have given examples, and those are part of the records, Lordship.
Are there any private respondents here?
Lordship, now the response number 4 is there. Although, Lordship, the service
notice is complete.
Yes, it's not service is complete, Lordship. And Lordship, we have made a prayer for striking out the name of response number 5 to 7, because despite service of notice, they did not appear. And due to some miscommunication, Lordship, we made a prayer that they may be struck out. But as per Lodging Court's report 1/9/2022, service report also was deemed to be completed in respect of 5 to 7. But anyway, Lordship, we have made a prayer to strike out the name of response number 4 is there, Lordship.
Notice is complete?
Notice is complete, Lordship. And on the last occasion, Lordship, may kindly see the last order, Lordship, passed by the Honorable Court.
Passed by this court.
Lordship. On 8/4/2024.
Nobody has appeared for the respondent for?
No.
Nayak, last time you wanted some time,
Lot of my affidavit is already there.
Mm.
I filed my affidavit.
when did you file your affidavit?
It was filed on 20th November 2023. Reply, sorry,
No, I do not require to file a reply here
No,
because.
no, that is
uh,
different. 8/4/2024.
Yes.
Not. Yes, 8/4/2024.
You have a copy of the order.
I have to go from.
You can see this. Because in their affidavit, Lordship, they have taken a stand. They have admitted, Lordship, that there are some candidates who were wrongly appointed.
Yes, Lordship, this process of inquiry is still going. Preliminary inquiry we have conducted, Lordship. And according to our inquiry, it was found that selection of the private respondents were also erroneous, Lordship. They were also not eligible. But right now, Lordship, we are at the stage of concluding that inquiry, Lordship, and subsequent order will be passed very soon, Lordship. But to our information, Lordship, these 4 persons has already retired, resigned from their post, Lord.
4 persons.
Yes.
4 respondents.
Private place. So the Lordship today may not record their resignation. I will have that instruction. But
Then you get instructions and come back.
yes, but their selection has also been found. as
Okay,
well.
but Mr. S.K. Das, then counsel for the petition on request made by Mr. P. Nair, the standing counsel has. When do you want?
Yes, it's in. Let this matter come after puja vacation or in the
Yes,
meantime.
Better after puja vacation to enable him to receive instructions.
75 to 78.
Respondent 2 has filed affidavit. You are appearing for?
I am applying for BTC, my lord. Last, I need some time because SR was the PM, my lord. Is some personal difficulty today, my lord.
SR
SR. I appeal for 77 and 78, my lord.
Okay. Third, Mr.
NZ Chaudhary.
NZ?
Chaudhary. On behalf of Mr. Yarpura.
You got the name? Chaudhary, the counsel appearing on behalf of Mr. A. Buyal, then counsel for the petitioner. On request made on behalf of SR Rabal and the standing counsel BTC. How much time?
Let it be after 2 weeks.
2 weeks time is allowed to file complaint.
Right.
Please, 2 weeks.
79.
Well, in this case, B constitution lacks in another formal, any other day after vacation.
Okay, on request made on behalf of B Kaushik, then standing counsel.
That elementary education.
Elementary education appearing for the state review petitioner.
Lord, they have filed a review petition in the year 2022 till date, madam. I don't know why they are not appeared in this case. And they have preferred the review application after a lapse of 5 years.
He was there, my lord.
List after the puja vacation.
80.
Lordship in here. Affidavit in opposition has been filed, Lordship. Lordship, may allow some time we'll file a rejoinder, Lordship. 2 weeks time, Lordship.
Okay, Mr.
NZ Chaudhary.
NZ. And so limit counsel. Appearing for the petitioner. Praise for
2 weeks time.
2 weeks time. To file reply to the affidavit in opposition. Filed by the respondent number 8. Correct.
Okay, AC, Lordship.
Respondent number 8, isn't it?
They, however, have not filed, Lordship, till date.
No, respondent number 8 has filed
8
affidavit.
is filed, Lordship, yes.
Who's the respondent number 8?
Private respondent.
It is the private
Praise
respondent.
allowed. List after 2 weeks.
81.
Not here, the order dated 9/12/2023 is yet to be complied with. Interestingly, Lordship, in this matter, what we find, there is a communication from the department there.
They are supposed to file an amended petition by the last.
That has been filed, that everything has been filed. Some of the petitioners withdrew from the main case, and after due permission from the Honorable Court, thereafter we filed the amended cost title. It is there. Go to first.
This is what, in the page 3 of your course title,
Is amended cost title we have filed?
after petitioner number 5, 6,
Yes, some of, yes, some of them have withdrawn from.
no, serial number after 5, 6, it is
5,
7.
6. Serial number 12 of the original petitioner. Original serial number 12 remains. That is why, Lordship, it has been written as 12. Original, the serial number 12 who was
Okay,
there.
okay. Yes, District.
None of the, Lordship, all the contenders have received notice, but none of them have responded yet.
Where's the order?
Order is at page 13. There was a direction for granting of pay scales from the date of joining. Order starts at page 15 and operative portion from page 18. Page 18, last paragraph. We can't wait here.
মই আগৰ হেৰি হৈ আছিলো আগৰ earlier here.
From the respondent. Mamta Hujai.
নাৰায়ণপুৰ কৰিলে ন তাৰপিছত
নাৰায়ণপুৰ কৰা হৈছে। কৰা হৈছে, সব notice পাইছে, সব notice পাইছে।
Yes.
I'll have to take instruction from the present secretary. He said my present secretary has been made a party, included as a party respondent.
Who's the present secretary?
And for.
Narayan.
Number 4.
Yes, I will take
Yes.
instruction. No, may kindly take it up next week.
Okay, heard MS the Burg Learned Council for the petition. On
Here I-
request made by SMT Chishti Learned Council for the
Respond number 2.
For the response number 2.
Need a week time to get the instruction.
Please to what?
Lordship, that may be recorded that he 6 times to bring instruction from the present secretary. That may be recorded.
Whether that service notice has been served, he said notice has been served.
Completed.
I'll have to get the instruction whether that it's been served or not.
No, it's complete. It's complete. It's not record.
Yes.
Check the record.
25th.
Yes.
Lordship, that may be recorded, because why I'm saying, because there is a communication from the department there, which I haven't found in any of the earlier cases, that they are going to communicate with the Honorable Court Director, something in that lines. There is a
How
communication.
can they communicate with the court director?
No, there is a letter. There is a letter. There is a letter.
That would amount to further contempt.
I don't know what they are.
Let him come. Let him
That
come
is why,
forward.
Lordship, I'm insisting that it may be recorded. He is praying that he'll bring instructions on behalf of the present secretary. That may be recorded.
He is not.
Whatever instruction I'll get.
Okay, let him come.
82.
May I please, Lordship? The direction, Lordship, of this Honorable Court, Lordship, is at page 17. There is a direction to refund the recovered amount, Lordship. 11 and 12, page 17.
Notice.
Yes, Lordship, already they are at hearing.
Finance is a party, yeah?
No, Lordship, direction was given to the respondent number 2, that is the director, Lordship.
As per this instruction, Lordship, finance need to be made a party.
Finance was a party in the writ petition?
Oh. No.
But the confusion is there is communication gap between the finance and the Lordship.
See, director has been directed to take steps.
Lordship, we have taken note.
You have taken and you just cannot keep quiet. You should pursue with the finance department also.
Yes, Lordship, but if from courts also it's an appeal, then it will be better. We'll pursue there.
When the finance department was not made a party in the writ petition, how can you bring them as a party in the contempt?
Lordship is correct. I'll ask the department, Lordship, I'll obtain the instruction, what is the status for it.
Okay. Heard M. Khan, learned counsel for the petitioner, Mr. A. Tabildar, learned counsel appearing for the
Respondent.
Sole respondent.
for the sole respondent, placed for 2 weeks time to enable him
Can
to
it be 3 weeks after puja vacation because it is.
But any date may be
to
given.
enable him
Lordship.
to file, to enable him to receive instructions, praise allowed. This after the summer puja vacation.
After vacation, Lordship.
After vacation, I'm not giving dates, otherwise there'll be big trouble.
83, Lordship, is similar direction was given.
Same order,
In
same order.
Why not even 84?
54 lawsuits, we have already issued a compliance order lawsuits.
I have looked at the copy.
হেৰি এটা প্ৰিণ্ট উলিয়াই দিওঁ আৰু এটা মোৰ জুডিচিয়েল direction was to lawsuit the comply that he has filed an appeal that has to be disposed of.
Is it perfect?
Last paragraph lawsuits.
We'll close the content.
You
You'll have to challenge.
Yes, I will give a copy of it right now. But my here WhatsApp number আছে না?
But Mr. M. Khan, learned counsel for the petition. Mr. SMT Chichti, learned counsel appearing for the respondent number.
That's the sole respondent.
For the sole respondent. Has furnished an order dated
Lawsuits
3/9/2024.
3/9/2024.
Issued by the Secretary to the Government of Assam, Department of School Education. Whereby the claim of the petitioner for error salary was found not tenable. And the petitioner, and it was held that the petitioner is not entitled for any error salary. Stop. But considering the order dated 3/9/2024, this court is of the considered of that the respondents have that the respondent has substantially complied with the order passed in this court. Accordingly, contempt is closed. The order dated 3/9/2024 is placed on the court.
85.
Look, here is a case, the order was passed on 19/10/2023. Setting aside the termination order and also there is a direction, Lordship at page 39, Lordship would find that they may proceed with the departmental proceedings. And if nothing is found, I will be entitled to the back wages till the date of termination. Now the departmental proceedings have also been disposed of without framing any charges. 42 and 43, there is a speaking order. That is 42 and 43. 42. Page 42 of the contempt.
Lordship, operative part is at 43, last paragraph. Last paragraph. May I read? Thus, in compliance of the Honorable High Court, Guwahati High Court, and the undersigned hereby has issued the speaking order for reinstatement of Suresh Das in his post of bearer with immediate effect of this speaking order along with the entitlement of his pay and allowances till the date of termination. Now, Lordship, he had joined service pursuant to this on February. He's not getting the current also, not the arrears also, Lordship. Next page is joining. Now the respondent number 2 has filed its affidavit, the principal, which says that he is the only the drawing and disbursing authority. At page 49, Lordship would find. Today they have filed, maybe not on record. But the respondent number 1 has to file the affidavit. Director has to file the affidavit of compliance. Okay, heard Mr. D.V. Bora and the counsel for the petition. Oh, no. Stop. Mr. S. Mukhtar, and the counsel for the respondent number 2 submits that he has filed affidavit this morning. Stop. Register you to verify and place the same on record. Mr. S. Das.
I am appearing for my daughter. One
Last time your Tabildar was appearing.
is for both names there. Name is there.
Both of you. Okay, Mr. S. Das, Leonard counsel. For the respond number 2, praise for.
I am appearing for respond number 1.
Praise for appearing for respond number 1, praise for.
2 weeks time, I'll
2 weeks time to file affidavit, prayers allowed. List after puja vacation.
deeply.
88. $88.
Wait, please, Your Lordship, was it 2 days time may be given to take steps upon respondent 5 to 9?
One. Have you taken steps?
Lordship, no, Lordship, 2 days time may be given.
This issue, last time you said that there was some this urgency in the matter and therefore you may be permitted to take dusty service. Have you taken dusty service?
No, Lordship, not it. It is ready, Lordship.
So you have not taken dusty also, no registered calls. Both.
Lordship.
Otherwise, he's the respond number 4, my lord, whose admission has been, my lord, basically. 5 to 9, they are pro forma respondents.
Five to 9 are pro forma only.
Yes, otherwise pro forma. Pro forma respondent.
But 4 also you have not taken steps.
No, Lordship. Only 2 days time may be given,
On the respondent 4 also you have not taken steps.
not taken.
It should have been taken, my lord, because he has been given the admission.
Okay. MS
D. Datta.
D. Datta, learned counsel for the petition. Submits that due to inadvertence, the petitioner could not take steps for service of notice on the respond number 4 and the pro forma respond number 5 to 9 by registered post AD as well as by dusty service. She therefore prays that the petitioner may be allowed 2 days time to do the same. Para. The petitioner is permitted to take steps for service of notice on the respondent 4 and the pro forma respondent 5 to 9 by registered post TD within 2 days from today. Stop. Para. Petitioner is also permitted to cause service of notice on the respondent number 4 as well as 5 and 9, 5 to 9.
That's it.
As well as the pro forma respondents 5 to 9 by dusty service through the registry of this court within 1 week from today. Draft petitioner shall file an affidavit to the effect. List after the puja begins.